the last paragraph was my lord's order while restoring the appeal. And thereafter 4th August it appeared. It was
ঠিকই তো বলছে না, কি করে নেমে যায় রসিক, নিজে নিজে তো স্লিপ করে নেমে যাওয়ার তো হয় না, এই যেন সে প্রশ্ন নয়, ওই গ্রুপের ভিতর নেমে গেল।
Mention, my lord, a matter. My lord, we have filed an application under compelling circumstances for recalling of my lord's order sitting with Justice Chattopadhyay. Because my lord has directed.
No question of because it will be listed. If you have filed an application,
My lord, on notice we have.
Whenever that bench is available, it will be listed.
My lord, the special officer is going to take, my lord, the position within the first week of September.
When was the order passed?
10th July, my lord.
10th July. Very well. Hey, শোনো এদিকে।
I am appearing for the respondent.
My lord, may I be permitted to mention, my lord, I'm appearing for the sole respondents. The sole respondent expired and the legal heirs of the sole respondents has been substituted, my lord. I'm praying for inclusion of the matter, my lord.
May I have my lord's kind leave to my lord move an application seeking leave to my lord file it without a certified copy and short service leave. I mentioned this matter last Thursday regarding my lord the order passed in an appeal in connection with mobile towers. We were permitted to remove it, but the my lord opposite party, the respondent, is not cooperating. My lord, may it appear tomorrow, my lord. That's why I'm praying for short service leave.
Lord, may I have your lordship's leave to mention a matter? I'm seeking leave to file the appeal without the certified copy, my lord.
When was the order passed?
The order was passed on 31st July, my lord. The reason I did not get the certified copy is the copying department there is closed. So it's very uncertain. Very grateful, your lordship. There's caveat I'll serve if it can be listed on Thursday, my lord. I'll come with after serving the other side, my lord. There's a caveat filed.
My lord, with leave of Honorable Justice Omnaran Rai, my lord, I beg to mention on your lordship single bench matter, my lord. My contempt application, my lord, out of 4, 2 already complied with, my lord. Let it appear in
it will appear when I sit singly.
Any day at 1 p.m. or 3:15 p.m.
Very well. Anything else?
With the leave of my lord Justice Rai, lordship had indicated to Mr. Aniruddha Chatterjee on the last day regarding that HITCO matter to
Yes.
to Mr. Jishnu Chaudhary.
Yes.
My lord, he had personally spoken with Mr. Chaudhary.
Yes.
Both of them have agreed to 29th of August, subject to the bench approving.
29th of August.
That's a Friday, my lord. If that is convenient to the bench, my lord, it's otherwise.
Hey, 29th কি অন্য bench কিছু আছে?
I'm mentioning upon notice, my lord.
Mr. Kormokar appears in the matter?
Yes, he also appears in the matter.
I'll have to talk to my sister, and if it's okay with her lordship, then it will be listed on the 29th. The time will indicate. Otherwise, we'll again bring it as to be mentioned, and
or we can ascertain from your lordship's officer, my lord, if it is not feasible on 29th, we will again, my lord, get a date and come and mention.
Better.
Grateful, my lord.
Ascertain tomorrow.
We'll ascertain tomorrow. Thank you.
The lordship, upon notice mentioning item number 69 of your lordship's list, the lordships, this is an appeal arising out of an section.
Which list, sir?
Daily list, your lordship. Original site, non-commercial.
Say so.
Original site, non-commercial.
So? Yes.
Your lordship, in this matter, it is for against an order for appointment of trustee, and the trust tenure is only 5 years, out of which already over 3 years have lapsed. So, praying for some special consideration. If your lordship fix any time or date, your lordship has your
No,
lordship.
sir, sorry, not immediately. Call the list.
Lord, I appear for the appellant. Lord, 8 different applications were filed which has been disposed of, my lord, by a consolidated order. But the appeal has been filed only against one. The other 7 appeal has to be filed. So, my lord, I was seeking, my lord, 10 days time,
Yes, yes.
so that, my lord, the other appeals can be in the meantime filed. One stay application will do. But, my lord, the other memo of appeals. have been-
8 applications were disposed
Yes.
of. Dekho dal, dako. Mr. Kaur, learned senior counsel representing the appellant, says that by the order impugned in this appeal, 8 different applications were disposed of by the learned single judge. Stop. 7 other appeals need to be filed. Stop. Paragraph as requested by Mr. Kaur, let this matter stand adjourned and be listed again on.
Lord, may I pray? Your lordship takes up, Lord, Mondays and Wednesdays as commercial matters.
Commercial Monday and Friday.
Friday. So, my lord, could it be on the 29th of August?
Yes, August 29. Stop. If in the meantime other appeals are filed, the same will be listed along with this matter.
Much obliged.
This is my appeal, my lord, against, my lord, an order dated 20th June 2025. My lord, the products are, my lord, Gold Flake and Gold Stag. My lord, 2 cigarettes. Now,
Who's for the plaintiff?
for the plaintiff. Now, packet full of ice. These were what I had handed up to your lord.
Yes, on the last occasion.
My lord, the interim order has been operating from 6th of February 2025. My lord, if your lordship takes the impugned order, my lord. Now, my lord, this has been now, my lord, on 14th of August, the Honorable Supreme Court has passed a judgment. My lord, Blenders Pride versus London Pride. My lord, there, my lord, the law has been, my lord, perhaps, my lord, a lot has been discussed which will apply in our case.
Correct.
My lord, the statutory warning, my lord, has to be there in all the packets.
Yes.
I'll tell your lordships, this was, my lord, from the order itself, my lord, one thing which will be clear, my lord, they say, my lord, it's a rolled
Therefore,
up action.
Mr. Roychaudhary, since when is this interim order
My
operating?
lord, 20th, my lord, 6th of February 2025.
Why we ask, we'll hear out the appeal.
Very well, my lord.
Let's not have multiple hearings.
Very well. My lord,
Give us a date. Are all papers before
yes,
us?
my lord. Because on the last occasion, your lordship had given a direction. My lord, we had filed certain papers.
A key
Mr.
direction,
Mukherjee said he would rely on certain additional documents. Now, those additional documents are also on record.
Sure.
My lord, 11th August, your lordship has passed an order. I am being led by Mr. Bose, my lord.
Yes.
The date fixed for appeal position. Yeah.
Mr. Rudraman Bhattacharya also appears in this matter.
He had appeared, my lord. He had appeared.
He had appeared.
Virtually.
So are you filing any bunch of documents or something?
What, my lord?
My lord, on that.
Yes, my lord, what has happened? My clients had filed 2 applications. One is GA2, which is vacating the order application. And my lord, there's an application GA4, which is that revocation of 12A. My lord, unfortunately, I find none of these documents are annexed. Even in GA1, my affidavit in opposition, sorry, their affidavit in opposition or GA1 as such is also not annexed.
Very well, Mr. Bose. To obviate all complications, file in informal paper book, incorporating all papers.
Yes.
Tell us how much time you need for
Well,
that.
Your Lordship, we can file it within.
Take instruction. Who you are not going to prepare it.
We should. I mean, there's some urgency on our ground. That's why.
One thing I want to make clear, my lord, there is no appeal, my lord, from my lord, the dismissal, my lord, of my lord GA4.
Well,
was for
Way.
My lord,
I've looked at the grounds. They
technically,
don't cover.
12, technically speaking, 12A is not an is an appealable order. I'm aware of that. I'm aware, but vacating certainly, if your lordship insists that why didn't you file a separate?
We insist on nothing.
No, my lord, they,
Paperbook should be there, my lord.
my lord, whatever.
My lord wanted the production of the trial court records.
That should be done.
That we will direct, no problem.
My lord, the paperbook should be there, my lord.
Yes, yes.
Correct.
Yes, Mr. Rashidri.
1 week. 1 week.
You can do it within 1 week.
1 week. Urgency also.
Issue.
My lord,
Having heard learned counsel for
on the prayer of my prayer, it's 1 week, but from advocate on record, on the prayer, you give me 10 days and fix it after 10.
Tell us, we'll give you any time
No,
you.
my lord, its prayer is 10. Paper book is 10 days. 7 days.
Counsel for the parties, comma. We are of the view that the appeal should be heard out since the order that is under challenge has been in operation since February 6, 2025. Paragraph. Let the appellant file requisite number of informal paper books containing all papers that were available before the learned single judge, within a week from date. Stop. All formalities are dispensed with. Stop. Since the respondents are here for all the respondents.
One respondent.
And others?
They never appeared.
They never appeared and supporting that.
Oh, since the respondent number 1 is represented through learned counsel, notice of appeal is deemed to be waived insofar as that respondent is concerned. Stop. Let notice issue to the other respondents. Paragraph lists the matter 10 days hence. That's what you said.
My lord,
10 days?
Next Friday to 10 days হয়ে যাচ্ছে almost.
What is the confusion?
My personal confusion.
No, you wanted 10 days.
Yes.
That's what we are saying.
Kindly make it 29th, my lord. That will suit them.
The 10 days লিখো না।
29 থেকে
তাহলে তার আগে করো 28
তাই তো
29
বলছে
28
29 ফিক্স করি স্যার সুজনের বলছে ওর 29
My
9th is a Friday.
he is not available, so
doesn't matter. Please fix it as it says. If it's 29th, please fix it on 29th.
You won't be there.
Not after 29th. There's some difficulty.
I know. I know.
So
What are you flying?
That's 29th got a Friday. It's a original site.
it's an original site day. তুমি
Yes, 29.
28th.
No, 29th is original site. It's a Friday.
28 বলতে
ঠিক আছে।
Is there any difficulty?
হবে না সেদিন কিছু।
হবে না? Oh,
It's a Thursday.
29th, are you here or are you?
yes, I am there. I'm there on 29th.
Let it be listed on 29th.
After that.
Or if you want 27th is also possible, which
I'm
is
20, but Mr. Mukherjee has some.
My lord,
Oh.
they have, my lord, both put me into a
29th.
29th is fine.
Put it out, 29th. Yes.
27.
স্যার কনভিনিয়েন্স স্যার স্যার
আপনার কনভিনিয়েন্স কবে?
আর কিছু নেই না আমার
তিলক স্যার
একই arbitrator
Well, please 29. I
জানো
স্যার অ্যাজ পার আপনার কনভিনিয়েন্স বলছে স্যার সুজন বলছে অ্যাজ পার আপনার কনভিনিয়েন্স
29th.
আপনার যেরকম
He has said, I told, in spite of that, you have said, now 29th. He will do the matter if necessary.
এবার আমাদেরও বকবে, সবাইকে বকছে।
My lord, I'm grateful to you.
Yes.
সকালেই হবে এটা।
and inform this paper book to be filed within, you specify the time.
7 days, your
7
junior said.
Notice of appeal is served.
A notice of appeal has to be served.
To the other respondents.
Has to be. We'll see, my lord.
We have said so in the order.
Yes.
My lord.
না ফেল অফ পাজল নয় ফেল অফ
Sir, বলতে গেলে কোনো একটা time fix করা যাবে তো?
Item number 3 lord I appeal for the appellant.
Yes.
Item number 3, Your Lordship, I am for the respondent. My lord, under peculiar circumstances, my lord, I have preferred this appeal before your lordship, before this honorable division bench. But what has happened, lord? This was a commercial petition filed by the respondent plaintiff hearing. But in the year 1998, blood, because if your lordship kindly turn blood page 2, paragraph 1, I am for the Madhya Pradesh government. Blood, 4th of November 1997, an agreement was executed by and between the parties.
Mr. Banerjee, just give us a few minutes. Let us go through the order.
The only thing, Lord, I want to, Lord, I bow down. Only one thing I want to draw your lordship's attention, because the suit was dismissed for default. Thereafter, restoration filed. That was also rejected. Then it went up to the appeal division bench. Honorable division bench was pleased to restore. But when the matter came up, Lord, earlier, Lord, another lawyer was presented the Madhya Pradesh government. But when the matter came up, but the main file was not traceable. Then, Lord, the order of Lord, the reconstruction of the file was passed. What has happened? The documents which we were relying upon, that was not placed. As a result, my lord, ex parte decree was passed. Then execution, Lord, we have filed a review when it came to our knowledge. We filed a review in pending. When execution petition was Lord, heard out, I repeatedly requested the land single judge. The review is pending, kindly allow me sometimes. But the review is not pending before him, before the another court. Lord, he passed the order, Lord. The land single judge passed the order disposing of the review application. My lord, kindly go through the documents, Lord. This is my case.
He was the different number 2. State of Madhya Pradesh was the different number 2.
May I also indicate the peculiar facts?
Let us go through the order first.
Such a kindly single.
20th June. This order has not been implemented as yet.
Order has been implemented, Your Lordship, the receiver has taken possession.
No, no.
I indicate, Your Lordship, the peculiar facts. 19,
Only Miller, the padlock has been put over there. Miller, the কোথায় এটা দুটো আছে না? তো বলবি তো,
Mr. Banerjee,
my lord.
the decree stands today. Rightly or wrongly, a decree has been passed. Maybe ex parte against your client. If you can.
Review is pending.
Hmm?
Review is pending.
Maybe.
Only Miller,
Maybe.
only Miller.
Same learned judge passed the decree, no? Another learned judge.
no order 9 rule
Sugata
35, no appeal preferred. Your Lordship, despite orders, Your Lordship, they have not come before the court. Bank accounts have been attached.
This order has been carried out.
No, no, not carried out. No, Lordship,
Has been
may I,
carried out, Your
Lord,
Lordship.
may
The
I-
alleged receiver
then
has taken the physical possession
subject to
of the
subject to
office.
correction of my land and
Yes, sir,
subject to
report has been
correction of the court. Lord, may I tell one thing, Lord? Lord, whatever has been carried out, Lord, I know, Lord, the padlock, put padlock over the, Lord, the office. Not only, Lord, I beseech to your Lordship, kindly adjourn this matter, Lord, for fortnight, Lord. Let us take a chance, Lord, because review is pending. Review is before Justice Sugata Mujumdar. Lord, kindly, Lord, but kindly, Lord,
Why should we keep it pending?
fortnight because of the fact.
Go and do whatever you can in the review. We are not stopping you. Go and file Order 9 Rule 13. We are not stopping you.
Already filed pending.
There's nothing in this appeal.
Lord, only Lord, may I say, ma'am, Lord, because Lordship kindly consider this, Lord, the entire records, ex parte decree, that too, Lord, when restoration. Lord,
This is not the court where you can urge that point. Please understand. This is an appeal from an order in execution. Correct. Decree is not under challenge before us. We can't touch the decree. Please understand, there are certain. You're a senior counsel. What
That
are
is
you
right,
saying?
Lord. I'm not paid for this step, but only, Lord, I within time I want, Lord. That's why, Lord, I have come before you.
Go. We are not stopping you. But there's nothing in this appeal. Either you withdraw it or we are going to dismiss it just now. It's up to you. This choice we are giving you.
Then, Lord, Lordship, kindly, Lord, I'm withdrawing this appeal.
Yes.
Kindly, Lord, give us, Lord, liberty, because we have already prepared this review. That was our contention before the land single judge.
We'll record that. You have.
Lordship,
Issue.
kindly, Lord.
This appeal is directed against an order dated June 20, 2025, passed by a learned judge of this court in an application for execution of a decree dated April 10, judgment and decree dated April 10, 2024. Paragraph. The respondent number 1 had filed a suit against the State Bank of India and the present appellant, praying for various reliefs. Stop. It appears that State Bank appeared in the suit.
Yes, yes.
Contested.
Partially, Your Lordship, decree has been complied with by the State Bank.
Stop. It appears that only the bank contested the suit. Stop. The decree was ex parte insofar as the present appellant is concerned.
Bank has also not contested, Your Lordship.
That is what I asked.
Bank has not initially bank appeared, but bank has
Initially, we appeared also, Lord. Thereafter, Lord, when the restored.
Guarantees which has been cancelled.
It appears, it appears that none of the defendants in the suit, including this appellant, seriously contested the suit. Stop. The suit was decreed in favor of the plaintiff, which is the respondent number 1 herein. Stop. The decree was put in execution by the plaintiff. Stop. On such application, the impugned order has been passed. Stop. The learned judge has appointed a learned advocate of this court as receiver to attach the property, to attach the office of the chief conservator of forest, ব্র্যাকেটে বালাঘাট সার্কেল, এই এখানে আছে, হ্যাঁ একটু দেখে নিও, পেজ 3 তে আছে ইমপিউন্ড অর্ডারটার, Balaghat Circle at Shioni Road before Gara Railway Crossing, Balaghat, Madhya Pradesh, such and such, and the office of the Divisional Forest Officer, South Production, etc., comma, by putting padlock on the said offices, stop, paragraph. Learned Mr. Banerjee, comma, learned counsel appearing for the appellant says that the appellant has filed an application for review of
Review of your lordship, the judgment and decree dated.
judgment and decree dated April 10, 2024.
RVW of 17 of
Being
2025.
RVW
17 of 2020. RVWO. RVWO
RVWO
number 17 of 2025.
25. Stop. The learned single judge ought not to have passed the impugned order without granting an opportunity to the appellant to press its review application. Paragraph. Have you filed an application under Order 9, Rule 13 for
No.
recall of the decree?
No.
We find that there is no application under Order 9, Rule 13 for recall of the ex parte decree. Stop. We cannot go behind the decree. Stop. This appeal is from an order passed in execution proceeding. Stop. We are further, paragraph, we are further told by by Mr. Shengupta, comma, learned advocate for the plaintiff, oblique respondent number 1, that respondent number 1, oblique plaintiff, that the order sought to be challenged before us has already been carried out.
I'm disputed with that, lordship.
And stop, carried out, stop. The learned receiver has taken possession of the concerned offices
Officer padlock.
and has filed a report to that effect before the learned single judge. Stop. This submission is disputed by Mr. Banerjee, comma, learned advocate for the appellant. Paragraph. Since the decree is not under challenge before us, comma, we find no ground to interfere with the order under appeal, which has already been implemented. Paragraph. The appeal and the connected application stand dismissed. Stop. This will not prevent the appellant from taking recourse to other remedies that may be available to it
I'm not
in
also
law.
Also review because
We have recorded the review is pending. We have recorded that in law.
But the learned single judge has heard because review is not pending before him. But he has said
review is not review disposed of.
Yes, he has said so.
He has not taken any steps, your lordship, to mention the matter, and your lordship list the matter of review.
No.
Before the learned single judge.
Learned single judge, that is review is not pending before him. Pending before the learned.
No, it has not been disposed of. What are you saying?
Main thing, your lordship, his prayer, one of the prayer is an order be do issue directing the receiver so appointed to open the padlock.
That's right. Appeal has not interfered with.
Your lordship, the padlock is not there. Why there is a prayer?
There is no.
I'm grateful.
Nothing to show the prayer now.
All right.
I'm deeply obliged to your lordship.
For hearing item number 4.
Before I start, I'll tell your lordship that there is some problem I have till the 28th. I won't be around.
Very well.
Quickly, he's going to the jungles to watch exotic animals. How can I?
Tadoba? No.
No, not outside this.
Kenya, Masai Mara.
Another, yes, not different continent.
Masai Mara. Both of you are going.
No.
When do you want it? Tell us.
Could it be on the 29th? 29th.
On the On the request made by Mr. Bhattacharya, learned senior counsel, representing the appellant, let this matter stand adjourned and be listed again on,
1st September.
Yes,
This is not-
can be September 1, 2025.
Isn't that homeopathy?
Homeopathy.
Yes, yes, you remember. You are for the plaintiff.
Defender. No, I'm for the defender.
All right. Come back. In the forest, in the jungles, there are these flies and insects. Carry some homeopathic medicine for that.
But let it be on the 29th online join kar lena na, because first is a monthly list, my lord.
That doesn't matter. That really doesn't matter. We don't have that fatter list anyway. 1st September.
I'll ask my client. He's a homeopathic doctor.
Item number 5.
This is my appeal, my lord.
Respondent, your lordship.
Yes.
My appeal. But the paper books have been filed. Ready for hearing, my lord. I can start.
Yes, you can start. All the respondents are here.
But I have had a word with respondent number 1, who's the effective respondent.
She says she is the respondent number 1.
One, I am led.
She's the respondent. But she's for the controller.
So Dhruv Surana, he's the Union of India Council 1, your lordship, senior council grade 1.
Who is for the respondent number 2?
The respondent number 2, Mr.
Arunabha
Arunabu Mukherjee is appearing. But I've had a word with him today. But
Yes.
he's in court. He has asked me whether if lordship permits, we can start. He will join. He's in court. But he's in fact in this floor.
Yes, we can hear you. We have no problem. Is it all right with you?
I'm not having any instruction, and my senior, I'm led by Mr. Dhruv Surana. If my learned friend, he.
No, we don't understand. If you don't have any instruction, madam, why are you appearing then?
Your lordship, we are allotted with a brief, your lordship. If instruction can be, necessary order can be passed, your lordship, I will communicate with Union of India.
Mr. Dashgupta,
My lord.
we can hear you, but it will be how, I mean,
Piecemeal
if
hearing.
they don't have any instruction, they won't be able to make submission.
They have been appearing, but although my learned friend who's appearing now, but I haven't seen her. But Mr. Surana was appearing. I've seen him.
So why don't you talk to him? He is the lead counsel, as she says.
Yes.
Otherwise, piecemeal hearing, it doesn't
But
really
I
work.
appreciate.
So we shall keep it when? Friday?
Friday?
Friday.
I'll come back on Friday.
Come back on Friday.
I request your lordship kindly necessary instruction I need from the Union of India, and they need a written order from the court, your lordship, if necessary order can be passed.
We have to direct Union of India to instruct you, and then only you can make submission.
We have to come.
They are
Sorry,
appearing.
no.
But Mr. Surana is appearing. But I know.
You better talk to him.
I'll talk to
him and bring him on
But,
Friday.
only one difficulty. My learned colleague Malad has some issue on Friday.
Monday.
It could be Monday.
Learned advocate for the registrar of trademarks says that she has no instructions in the matter. Stop to enable her to obtain instructions, we adjourn this matter and direct it to be listed once again on Shamne Shombare date. Now we have passed an order. Now we hope you get instructions.
Grateful.
My lord, appearing on behalf of the petitioners, my lord.
Yes.
My lord, I am being led by Mr. Shaturu Banerjee in this matter. My lord, I'm praying for any day after 20th August. My lord, my senior Shaturu Banerjee is is out of station. And
is he out of station or out of country?
My lord, I am unaware of that. My lord, he's out of station and
you don't keep track of your senior where he is. Yes, sir.
I sincerely
I am
apologize, my
appealing
lord.
for the respondents.
Yes.
Being led by Mr. Anirban Ray, like
Yes,
we had
yes,
completed
we remember that incorporation of that
assignment of the arbitration clause.
arbitration clause. হ্যাঁ করে দাও কবে করবে 20 তারিখের পর চাইছে 22nd
My lord, my lord.
তুই নেই না
Lordship, 22nd, my senior is not there. Can it be on 21st?
No, can't be on 21st. It can be then on 25th.
My lord.
25th also, Your Lordship.
Who is your senior?
Mr. Anirban Ray. Lordship, next
27th.
Yes, Lordship. My lord. Very grateful, Your Lordship.
My lord.
On the request made by learned advocate for the appellant,
Yes, my lord.
comma, let this matter একসঙ্গে হচ্ছে let these matters stand adjourned and be listed again on কবে বললাম 27 August 27,
My
comma
lord.
2025.
Item number 8 and 9.
Item number 8 and 9, I appear for Haldia Development Authority.
Shorojit Dey is appearing.
Next is he'll be within a few minutes.
EOPT 76 of 2025 Tatina.
No. You had started this matter.
Yes, yes, Lord. I have already started, and Lord, few documents are required to be shown, but I have to recapitulate because in the meantime, long time.
Paper book the.
6 volumes are there.
Who was the claimant before the arbitrator?
Lord, we are the player.
You are the claimant.
Volume গুলো দিন। Status, sorry.
Your claim was partly allowed or fully allowed?
Partly allowed, but my lord, I have challenged my principal prayer before the learned arbitral tribunal was for release of the security deposit. My case was I have completed the work. Despite successful completion of the work, certificate has been issued in that regard. There is a specific endorsement in the running account cum final bill, and there is a particular provision clause 6 which categorically says that a certificate is required to be issued by the executive engineer after completion of the subject project. That certificate has been issued and that has been endorsed in the running account bill. Despite that fact, the security deposit has not been released. When I made the prayer, subsequently the learned arbitral tribunal has awarded a counterclaim. So, my lord, the awarding of the counterclaim is contrary to the contract, and this is a patent illegality and is based on no evidence. So, I have, my lord, filed a Section 34 application. In the Section 34 application, what the Honorable Single Bench did, my lord, instead of the considering my application, there was a computational error admittedly. So, this computational error has been rectified, and so far as the quantum of counterclaim is concerned, that has been enhanced. So far is the principle of allowing the counterclaim that has not been considered. So, my lord, may I please?
পেপার বইটা দাও না, উনি কিছু লিখছিলেন হয়তো পেপার বইতে।
Only I will take 5 minutes for the recapitulation, and thereafter, my lord, I will place.
Yes.
So therefore, my lord, so far as the allowing the security deposit is concerned, I am not, my lord, placing any document, only which are not, which are relevant. Otherwise, my lord, my submission would not be completed. My lord, kindly have a look at page 68 of volume 1. The nature of work was for the construction of the road from the Milord Gwalpukur to Tekhali Bridge, Ahmedabad, High School of the Nondigram, such and such. The name of the work is very important. This is a construction work. Construction of the new road. Construction of the road of the Gwalpukur to Tekhali Bridge. The period for the completion was 180 days. That has been mentioned in 1C. Time of the completion is 180 days. Then, my lord, kindly have a look at page 69. P, that is 1P. The bidders shall be required to properly maintain the road, including the component of the period of the 3 years. That means the defect liability period was for a period of 3 years. Every after the completion of the 1 year, the 30% of the security deposit would be released. So my obligation is 160 days. If there is any extension of time, that would be there. Thereafter, for a period of 3 years.
180 days.
180 days. Sorry, 180 days. That means the 6 months. Then, if there is any extension of time, that would be which has been granted, and thereafter 3 years. My obligation would be within that period only. Then, my lord, kindly have a look at page 95. This is an work order. My lord, the construction of the road from the Gwalpukur, this is the name of the work. Completion time is the 180 days. Then, my lord, next page, page 96. I am drawing your lordship's attention so far as the clause of termination is concerned. Kindly take a note of it, my lord. The termination in the event of your unsatisfactory progress, you will be given a notice of the 7 days in order to cover up the delay for gearing up, covering the delay for the gearing up of with the due expedition, and to the event of the improvement in your performance, the authority reserves its right to terminate the contract and get the balance work to be executed at the risk and cost of the petition yourself. And you will execute and complete the job with the proper quality control during this stage of this construction, meticulous planning, and the adequate method of the construction. So, my lord, for the termination of the contract, this is sine qua non. A prior notice of the 7 days is required to be given prior to the termination of the contract. Kindly, my lord, take a note of it. There is a, my lord, the defect liability period. This nomenclature was not there, but the, my lord, the maintenance period has been mentioned. So, maintenance period was the agency will have to be maintain the road in good condition for a period of the 3 years from the date of the completion of the work. Then, my lord, kindly have a look at page 316, volume 3. My lord, this is fourth and final bill. First, second, and the third running account bill has been paid on regular interval. Subsequently, there has been a substantial delay, but the fourth running and final account bill has been prepared, where it has been mentioned by the authorities. Date of completion is 24th of September 2010. Kindly take a note of it. 24th of September 2010, and date of measurement is that date, but it is not eligible. That's why, I am not 20th of September 2010. 20th of September 2010. This is the date of measurement, and date of completion is 24th of September 2010. Just conjoint reading of the two. That is, clause 6, page 83 of the volume 1 once.
Clause 6, page 80.
83 of volume 1.
Impossible to read.
I also have seen that this is so.
No, I mean, absolutely impossible.
May I, for your lordship, may I read it? May I read it?
No, you read it now, but we will not remember.
I will give a copy.
Yes.
দেখো তো এটা জজ সাহেবের আরবিট্রেটরের অর্ডারটাও লেখা আছে।
নাকি আমার চোখটা খারাপ আরো খারাপ।
In completion of the work, the contractor shall be furnished with a certificate by the executive engineer authorized officer, hereinafter called the engineer in charge, of such completion, but no such certificate shall be given, nor shall the work be completed until the contractor shall have removed from the premises on which the work shall be executed all scaffolding, surplus, material, rubbish, and such. So it is the obligation of the executive engineer to issue a certificate after completion of the work. In consonance, a certificate was issued. That is page 357, volume 3. Stands corrected 359. Internal page 88. This is certified that the work has been completed as per terms and conditions. Date is very important. 16th of July 2015. Kindly take a note of it. 16th of July 2015. Subject project has been completed on 24th of September 2010. This certificate is being given on 16th of July 2015. And thereafter, there has been a deduction of the general CGST, SGST, and thereafter the amount which would be payable, that the calculation has been mentioned in internal page 89. So this is the fourth running account bill. In consonance with the clause 6, they have issued a certificate saying that subject project has been completed. There is a clause 2, that is the liquidated damages. I will place few letters wherefrom it appears that despite giving notice, we did not complete the remaining portion of the work. Despite the fact there is a clause 2 for the imposition of the liquidated damages, if I fail to do the work within the proportionate time schedule, in that event, it is imperative that would be imposed, and total amount, the 10% of the security deposit, would be deducted. They have chosen not to impose clause 2 of the conditions of the contract. Then, I am referring 256, volume 2.
NIT for the unexecuted portion of the work.
There is an issue. Kindly see the name of the work.
Repairing and resurfacing.
Repair. This is not the construction. This is the repairing and the resurfacing of the bituminous road from the Gwalpukur to Ahmedabad High School. When that has been floated, notice inviting tender was floated, appearing at page 260, 8th of February 2016. after 6 years or 5.5 years, I think, because subject project has been completed 24th of September 2010. This notice inviting tender was floated on 8th of February 2016. The nature of the work is repairing and resurfacing of the bituminous road.
8th or 10th? Where are you getting that 8th date?
8th of February 2016 at page 260.
At page?
260 of the volume 3, volume 2. Kindly see the signature and the memo number is main mentioned. 8th of February 2016. So the nature of work is quite different. Due to the natural wear and tear, the road would be not in a position where I have constructed. Subsequently, after 6 years, there was a situation where the repairing has been warranted, and therefore the repairing work has been executed, or that has been ordered, that has been for which subject project has been commenced. So 8th of February 2016. The work order was issued on 3rd of March 2016 at page 276 of new work. 276, volume 3. The work order for the repairing and the resurfacing of the bituminous road Gwalpukur to Ahmedabad High School. Kindly take note of it, the amount put to tender and the contract value. Amount was 78 lakhs 14,616. Period was for 6 months. They have not completed the entire work. I am showing from there, the final completion certificate at page 279. This is the payment certificate of what they are allegedly claiming the remaining portion of the work. Although the contract amount was 78 lakhs, they have actually executed the work of 73 lakhs 9,922. The question arises, in every time, the contract amount need not be completed in its entirety. It depends upon the site condition. And so therefore, if the site condition does not deserve that the entire work would be completed in consonance with the BOQ, the lesser amount can be executed and completion certificate would be issued. And there would be excess saving statement. It depends upon the nature of work and the site condition also. So, they executed the work of 73 lakhs, but there is a the work has shown to be completed. Then, I am coming, so far as the arbitral award is concerned, how the issue has been dealt with, shockingly unreasonable and irrational. Page 595, volume 5. If I place all the issues and how the issues have been replied, if I don't place this few contemporaneous letters, in that event, I would not be able to impress your lordship. So therefore, I am drawing your lordship's attention, few the letters prior to the referring of the 595. Page 196 of volume 2. Milord, this is a letter addressed to the Milord, the executive chief engineer, the chief executive officer. In first two line, it appears that 80% work has already been completed from this end. That means, Milord, the claimant has completed the 80% of the work as on 25th of August 2009. Then page 231. Milord, 4-5 letters, this is very important because my learned friend also will show. Milord, page 231. This is dated 13th of December 2010. Subject project has been completed 24th of September 2010. This is 13th of December 2010. As you have not started the work after the rainy season, though you have promised to do the same, time is running out, lot of work will still pending, including the repair work and the site soldering work. The office has tried best to contact you over telephone, but the most of the time you did not respond. Unwillingness to complete the work and has been viewed very seriously. If you do not start the work immediately, this office will have no other alternative but to impose penal clause on you for willful negligence to work as per the terms and conditions of the work. Whether the time extension has been given or not, there is no document fortifying the fact that the time extension, although sought for, that has been given to me. But they are writing letters after completion of the work. Next, 232. In spite of the repeated verbal order, this is dated, Milord, 5th of January 2011. In spite of the repeated verbal as well as the written request, you have not started the work till today. It is willful negligence of the work from your end. The local people are facing hardship due to the non-completion of the work. It has been viewed very seriously. You are directed to start the work within 7 days of the receipt of the letter. Otherwise, the HDA, that means the respondent, have no alternative but to get the balance work done through the other agency at your risk and cost, and any claim of the payment from your end will not be entertained. This is dated, Milord, 5th of January 2011. Next letter is 9th of February 2011. In spite of the repeated verbal as well as the written request, vide above referred memo, you have not started the work at site till today. It is willful negligence towards the work from your end, and the hence as per the clause 29 and the 16 of the general conditions and specifications, your contract on the may be cancelled and the balance work may be done through other agency at your risk and cost. In addition to that, and the further penalty may also be imposed upon you by the authority as per the provision of the clause number 16. Therefore, as mentioned, at termination clause of the work order, you are hereby served this notice to start the balance work at site within 7 days from the date of the issue of the letter. Otherwise, the contract will be terminated, and balance work will be executed by deputing other agency at your risk and cost. Next letter is appearing page 234, dated 1st of March 2011. With reference to the office memo under reference, where you were requested to rectify the defective work and to complete the balance work of the subject cited road as per the conditions of the contract. But it is surprising that you have not taken up the work till today, neither you have submitted your reply. It is viewed very seriously. It is treated a gross breach of terms of the conditions of the contract. However, you are hereby given the last notice to explain your position within 7 days from the issue of the letter, that why the contract will not be terminated for not executing the work as per the specifications and for the gross negligence of the work, failing which it will be presumed that you have nothing to say in this regard and the work order will be terminated will be terminated. Will be terminated without further correspondence to you, and your all dues, including the security deposit, pending payment, etc., will be forfeited, and the letter may be treated as the final notice prior to the termination of the contract. Then, my lord, 7th of March 2011, the claimant wrote a letter replying as to why, my lord, he had been prevented from executing the work. In response to your letter under reference, I am to state the following facts for your information and the kind consideration. The entire road length, as per the tender, has not been handed over to me due to the site problem from the very beginning of the work. The matter of the local disturbance was brought to your kind notice and to your engineering personnel time to time for the redressal, but of no result. I had to carry out the execution of the work with great inconvenience. So far as the work was completed by me, satisfactorily. Very often, the local people forcibly stopped my work, causing the idle labor and maintenance. As a result, I was put to heavy financial loss. In spite of this, the major portion of the work, construction of the twin box bridge with the approach road and the rectification of the bituminous work, was satisfactorily completed by me. At some stretches, from starting of the road at the middle of the village, such and such, near Temple of the Ahmedabad, no work could not be taken up due to the obstruction of the local people, in spite of the several persuasion from your end, as well as my personal effect. The attitude of the local people is not at all congenial to execute any further work, where I have been threatened for my life risk, demanding heavy amount of money. In this connection, it is mentioned that during the execution of the work, the demand of the money as made by the political and the local people was fulfilled, but no further demand is possible to meet up by me, since the demand of the money was not possible to meet up, and the people forcibly took away the stone chips, hammer metal, cement, bitumen from site. They also damaged my road roller without any cause. Further, regarding the mode of the payment, I was never billed and paid the value of the date of the work of the RA bills, in spite of my constant approach to the engineer and the joint site inspection. Due to non-payment of my up-to-date work and the delay in the preparation of the submission of the bill, I am facing severe financial crisis till the payment of the diversion road, ring band, piling work with the bolla and the other bags, which were executed by me during the construction of the box bridge, has not been billed for. Under the above fact and circumstances, I am not in a position to execute any further work in this site. So you are earnestly requested not to impose any penal action on me, since there is no willful negligence towards the work on my part. I also appeal to you for arranging to my balance payment of the work done by me and terminate my contract honorably. Next letter is 29th of March 2011. Only 2-3 letters are there. This has been written by the claimant. The same fact has been narrated. Only I will place penultimate paragraph and the last paragraph. And if your lordship see, I can place in its entirety. There is no difficulty, my lord. Since those stretches has not been handed over to me at all, from the fact and the circumstances stated in my letter dated 7th of March 2011, in this letter it is clearly revealed that there occurred no violation of the specification and negligence on my part in completion of the work. So I earnestly pray to you for honorable termination of the contract and arrange to pay the final bill for the completed work done by me and security deposit money lying with you. Then 237. This is a third-party letter that has not been used, that has been written by the block development officer to the district magistrate, saying the conditions of the road and the urgency also, because I am not privy to it, because no copy has been given to me. I am not privy to it, my lord. Then, my lord, page 255, volume 2. This is dated 10th of, my lord, 10th of August 2015. This reference has been taken in the, my lord, where the issues have been framed. This letter has been issued. This letter has been considered. 10th of August 2015. The certificate was issued, my lord, for the month of July 2015. The certificate I have shown to your lordship, my lord. You get it, my lord, 254. With reference to the above, and this is to inform you that the above mentioned work was awarded to you, vide the work order under reference. You have executed the work, leaving the few stretches incomplete and with deviation of the specified thickness of the road, strata, and for some road stretch. You have rectified the part of that road stretch as per the instruction of the office, but the entire rectification was not done by you. You are directed to complete the balance work along with the rectification of the road for the balance stretch, though the several communication from this office, but you did not execute the same, mentioning the reason for the local disturbance, and the work has left unattended since the October 2010. The condition of the road has become miserable as the road has severely damaged at several locations since March 2013, and you did not perform any maintenance work for the road. The Sobhadipati Nundigram 2 block has submitted a letter dated 27th of August 2015 mentioning the poor condition of the road for non-maintenance since 2010, and the District Magistrate Purva Mednipur has also shown a deep concern due to the such miserable condition of the road. Therefore, you are directed to restore all the damaged road portion as per the satisfaction of the concerned engineer of the office within 15 days after receiving of the letter, failing which the entire security money deducted from your bills will be forfeited by the office without any further intimation to you. You are also directed to give intimation to the office regarding the said road restoration work. In one hand, they are giving certificate, in other hand, they are writing letters. So, my lord, my respectful submission to all those letters, that I have completed the substantial portion of the work. That is, initially I have shown to your lordship that 80% work has been completed. One letter is also there, my lord, I will see, my lord, I will show that, my lord, the 90% work has been completed. Just I cannot find it out, my lord, in the interregnum, I can show your lordship. So, my lord, it appears from the contemporaneous document that I have completed the work. It also appears from the document itself, there are resistance, local disturbances, for which few stretches could not be completed and few stretches has not been handed over to me. I have intimated the same thing to the authorities. Authority did not take any call during the, my lord, during the existence of the contract. The existence of the contract, that means, my lord, when the work order has been issued, the work order was, my lord, has been commenced on 15th of February 2009. If the 15th of February 2009, as per the work order, which has been shown in page 95, the date of completion, my lord, that has mentioned 24th of September 2010. So 3 years defect liability period or maintenance period, whatever may be the nomenclature, that will go to, my lord, 23rd of September 2013. So my obligation to maintain the road is till 23rd of September 2013, not thereafter. There is no document on record that after the completion of the subject project or prior thereto, one letter I have shown, my lord, I will see, my lord, I will show, my lord, where from it appears that I have sought for extension of time. That extension of time has not been considered. But unilaterally, they are writing few letters with a view to demonstrate that I am having obligation to be discharged with. Although there is no provision for the, my lord, unilateral extension of time. Only there is a provision, clause 5, which says categorically said, if the time extension is required to be given, the, my lord, the contractor has to write his inability to complete the work and the difficulties what he has faced, and thereafter, my lord, on the basis of his, my lord, the writing, that would be considered by the executive engineer and his decision would be final. But, my lord, there is no single document in this, my lord, before your lordship, which fortify the fact that, my lord, the time extension has been granted in 2015, 2013, 2011 onwards. So, my lord, then, my lord, I am referring page 595 of volume 5. My lord, two pages are required to be seen, my lord, jointly, because issues and how the issues has been replied. My lord, page 595. Issue number 1. Are the claims and counterclaims made by the parties maintainable in law? Then page 647. Claim of the claimant allowed in terms of the above finding, but counterclaim of the respondent is dismissed. (647). Then claim number 6. Did the respondent rescind the contract in terms of the clause 3A, 3B, 3C of the conditions of the contract? For risk and cost, 3C has been mentioned. That is, my lord, 604, volume 5. 604, volume 5. It would be, my lord, 605, my lord. 3C says, clause 3 says, my lord, 604, in any case in which under any clauses of the contract, the contractor shall have rendered himself liable to pay compensation amounting to the whole of the security deposit, whether paid in the lump sum or decided by the installment, the executive engineer authorized officer on behalf of the authority shall have the power to adopt any of the following courses as he may deem best suited to the interest of the authority. Then, my lord, kindly see page 605. To measure up the work, this is condition precedent. To measure up the work of the contractor, to take such part thereof. If, my lord, the 10% is remaining left, this 10% is required to be measured up, and this 10% is required to be given to the other contractor. Not extra work. To measure up the, my lord, got it, my lord?
Yes.
605. To measure up the work of the contractor and the take such part thereof as shall be unexecuted out of his hands and give it to the another contractor to complete, in which case any expenses which may be incurred in excess of the sum which would have been paid to the original contractor, if the whole work has been executed by him of the amount of which excess of the certificate in writing of the executive engineer, the authorized officer final and conclusive shall be borne and paid by the original contractor, may be deducted from any money due to him by the authority under the contract or otherwise, or from his security deposit, or the proceeds of the sale thereof, and sufficient part thereof. To adhere to or to, my lord, to comply with the provision, there should be a termination of the contract or revocation of the contract. Immediately revocation of the contract, the remaining unexecuted portion of the work is required to be measured up. The document to that effect need to be placed. After the remaining portion of the work, that portion is required to be given to the third contractor. The third contractor will execute the work. The difference amount which have been estimated for in my purpose and the additional expenditure which would be incurred for doing the remaining portion of the work, I would be, my lord, obliged to pay only the difference amount. So in the instant case, my lord, then I am referring, my lord, issue number 6, which have been replied in 647. That is F, 647. Affirmative in respect of the clause C. The issue was, did the respondent rescind the contract in terms of the clause 3A, 3B, 3C of the conditions of the contract? The affirmative in respect of the clause 3C, although there is no single document, the subject project has been terminated. Although there is no single document, the subject work has been measured up. Although there is no single document that if the measurement has not been there, and therefore the remaining portion would not be given to someone. So single document is not there, the based on completely based on no evidence and complete perverse. Finding is completely perverse. There is no single document, the subject project has been terminated. And while considering, my lord, or replying this issue, the Honorable Tribunal did not consider the fact that subject project has been completed. It is not my document on 24th of September 2010. And, my lord, they have issued the certificate for the month of July 2015, which has been shown in a particular document, my lord, I have shown to your lordship. So certificate and, my lord, there is a completion of the work. This relevant consideration has not been done. Relevant evidence has not been considered by the Honorable Tribunal while considering or replying this issue. Therefore, this finding is perverse. Relevant consideration has not been considered. Then, my lord, 7. Whether the contract in the question was foreclosed and or terminated on 30th of November 2011 and the respect of the claimant on the 7th of March 2011 and 29th of March 2011. That means that different letters I have shown to your lordships. 647, it is 7. Negative in view of the above finding has not been terminated, court hold. 8. Did the respondent issue notice under the clause 2 of the conditions of the contract whether the liquidated damages has been imposed for my failure in executing the work in a proportionate time schedule? 8. 8 has been replied negative. H. That means liquidated damages never been imposed. Then, 9, issue number 9. Had the claimant completed the work on 24th of September 2010? Had the claimant completed the work? The document which has been shown, my lord. Issue number 9, negative. So there has been a complete disregard of that fact that it is the respondent who has made an endorsement and given the date of the completion of the work in their running account come final bill. It is not I who have written all those things. So that aspect has not been considered. Therefore, my lord, it hold negative without there being any basis. Then, my lord, then 11. Had the respondent rightly withheld and forfeited the security deposit of the claimant? Two things cannot be done. If I have failed to did the work, if I failed to do the work, in that event, I am not entitled to get security deposit. My security deposit would be forfeited by invocation of the 3A, B, and C. In one hand, you will say that I am entitled to get security deposit. In other hand, you will say that you have failed to complete the work. That cannot be go side by side. So, my lord, the 11 has been given. Issue number 11, negative. Has the respondent rightly withheld the security deposit for the such and such? Hold negative. That means I am entitled to get security deposit. Then, my lord, kindly have a look at 12. Whether under the terms and the conditions of the contract, the respondent is entitled to get compensation for the incomplete job done by the third party at the risk and cost of the claimant. Risk and cost of the claimant. 13. Only adjustment of the excess amount paid as discussed and to the other contractor. So what adjustment, my lord, saying, my lord, I do not understand, my lord. What adjustment has been referred to over here? Then, my lord, 13. Then 15. Whether the respondent is entitled to liquidated damage and 10% of the contract value adjustable from the pending bill, security deposit and the performance guarantee in view of the admission of the claimant, and that has not been able to complete the job under the contract. 15 has been hold negative subject to the above finding. And 14 is also important, my lord, I have missed. 14 is at page 596. Whether the respondent is entitled to counterclaim for an award of rupees 73,09,922 against the claimant along with the interest towards the risk and cost for execution of the incomplete work by the third party. 14 has been replied partly allowed only in respect of the deduction from the security deposit. If I am obliged to pay the counterclaim, so therefore I would be obliged to pay in his entirety so far as the difference amount is concerned. Part the counterclaim would not be allowed. The exact amount is required to be paid. If I have failed to execute the work, if the remaining portion is remaining left. So, sorry. Milord, how these the issues have been dealt with? Only I will, milord, show few observations of the Honorable Tribunal. Milord, the original award starts from page 583 to 648. Only the relevant observation, milord, I will place at 624. Got it, milord? I have carefully considered the submission made by the learned advocate for both the parties and peruse the material on record and regarding the claim of the claimant, and the work will be treated as completed as far as the finding of the respondent authorities in disposing of the final bill. In 3 phases of the first, second, and the third bills were passed, in which the work was stated as completed. Obviously, it will mean that inference has been drawn. Obviously, it will mean that by the word used by the respondent authorities in respect of these bills meant partial work done by the contractor, not the entire work. It is also the submission of the respondent number first, second, and the third bills were paid not against the settlement of any completed work performed by the contractor in 3 phases, but the same will be treated as payment in advance for the purpose, which was ultimately adjusted in the 4th running account cum final bill. It is also the case of the claimant that admittedly she could not complete the entire work. In the letter dated 18th of February 2009, issued under memo number such and such, work was issued at exhibit such and such specifying the completion of the time of the 180 days with a clear stipulation that the time is the essence of the contract and the no extension will be granted without the valid reason. In the event of the delay on the part of the contractor, the liquidated damages will be applicable as per the standard terms and the contract. In the tender order, it was also provided under the head security deposit that any amount equal to the 10% of each running account bill to be deducted from the bill of the contractor, subject to the maximum of the 10% of the contract value. The security money plus initial security deposit in the form of the earnest money will be released as per the clause 3 as at the page 18 of the tender form. So the first paragraph, the first portion of this, milord, the observation does not tally with the second paragraph of the observation. Then, milord, page 626. K. I am referring, milord, paragraph K. From the document on record, it appears that by a letter dated 13th of December 2010, what I have shown to your lordship, milord, letter dated 5th January 2011, letter dated 9th February 2011, and the letter dated 1st March 2011, the respondent was repeatedly asking the claimant to complete the work, including the repairing of the road, but no document is forthcoming from the end of the respondent. Very important, my lord. But no document is forthcoming from the end of the respondent that they have officially extended the period. They have officially extended the period and dispose of both the aforesaid two applications of the claimant, namely Exhibit R4 and C11. R4 I have shown to your lordship, my lord, 80% of the work, that is at page 196. I will show, my lord, page 106 of volume 1. $106 million. This is dated below 20th of April 2010. Just only I will show below the first paragraph. In connection with the above noted work mentioned job, it is to bring to your kind attention that 90% work has already been completed from this end. Then, my lord, the prayer. So all the work will have to be closed from the end and assured the complete the after the approach is properly made. The approach means approach road. Properly made. We will complete the work in all respect from this end. Necessary extension of time may be considered in this regard. Necessary extension of time may be regarded in this regard, and therefore you will kindly consider the prayer for kind perusal. So the Honorable Tribunal categorically made a finding that when we have sought for extension of time in two occasions, they did not come forward by extending the time. Since the time has not been extended, it has come to an end and the contract was not alive. Then, my lord, 629, page 629, 28, my lord, 28 in one observation, first, second, third, fourth paragraph from top. Therefore, it is on record that to the knowledge of both the parties, the tenure of the contract was alive on the date of the joint inspection up to 31st of October 2010. Where from, my lord, this observation comes? There have to be, my lord, the extension of time. There is no extension of time. Only, my lord, this observation is completely based on no evidence. Then, my lord, 629, paragraph P. Such warning was not, however, peremptory, as in the subsequent correspondence hearing dated 9th of February 2011 from the Chief Executive Officer, Haldia Development Authority, against the claimant reflected the intention of the respondent regarding the tender work will be reflected as regards the continuation of the such further mode of the termination of the contract as the case may be. From the content of the letter, it appears that the respondent has taken a decision. Respondent has taken a decision in principle to terminate the work in terms of clause 29 and clause 16. 29 and the 16 is completely in the different context. So, my lord, has taken a decision in principle to terminate the work order in terms of the clause 29 and the 16 of the general conditions and the specifications, and serve the letter in the form of the notice to the claimant to start the balance work at the site within the 7 days from the date of the issue of the letter. Otherwise, the contract will be terminated, and the balance work will be executed by deputing other agency as per the risk and cost, treating the letter as most urgent, and this letter indicates the intention of the respondent to extend the tenure of the contract. So that the decision taken by the authority, there is no reflection, no document. Only, my lord, few letters have been given saying that the contract will be terminated. This notice has been mentioned in the few letters. So the decision never been reflected that I do hereby terminate the contract. No such document is there.
Mr. Dotto, we have heard you enough. Start winding up now. You haven't yet shown us the learned single judge's order. That is the most important thing. You are arguing like you are arguing an appeal on merits.
Only want to
The
observe.
section 37 matter. You have forgotten that.
Then, my lord, I am coming to, my lord. So, few observations of the, my lord, the Honorable Tribunal.
We'll first read now, enough is enough. We'll read the learned judge's order, the impugned order.
From the memo, my lord, I am referring.
You take your seat. Yes, now you tell us, where's the error in the learned single judge's judgment?
Paragraph 20. At page 6.
Yes.
Upon hearing of the learned counsel of the parties, the following issues were framed. Whether the claimant is entitled to refund of the security deposit. Next is whether the compensation can be awarded to the respondent. Then, my lord, paragraph 26.
Yes.
Paragraph 26 at page 8. First, there was no termination of the contract at any point of time.
Yes.
Clause 3A provides that the security deposit of the contractor and the sale stands forfeited, be absolutely at the disposal of the authority.
No, this first issue has been decided in your favor.
Yes.
So why are you reading it?
No. Only few observation which is contrary.
Yes.
If I am entitled to get first, I will get the second. It is not that I will not get the second.
What is the second? Second issue?
Second issue is for whether, my lord, the compensation can be awarded by the respondent risk and cost such and such.
Yes.
Well, just only 2-3 lines I will show. There is no termination of the contract at any point of time. So if the no termination of the contract, in that event, my lord, the clause 3C would not be there. If the 3C would not be there, no awarding of the risk and cost would not be there.
Correct. Yes.
Then, my lord, on the contrary, paragraph 27, on the contrary, instead of terminating the contract, the respondent went on to passing the bill of the final bill, continued to make the payment of the final bill in the different phases, the bill such and such. Then, my lord, which is wrong observation, 28. Secondly, completion certificate were issued different phases. There is no provision for issuance of completion certificate of any phases. Different phases of the work and the payment were also made. Accordingly, the respondent has stopped from arguing that the entire work was not done, only in which case the security deposit such and such. So my observation is different phases. Then 29, last minute, 29, third line from top. However, the measurement books and the which are documents admitted by both the parties clearly indicate that a substantial portion of the work was actually completed and final bill raised, passed and the paid. The word substantial. If the work would be completed, there is no scope, there is no Miller clause at all. Substantial part or something else. We have to do the work in its entirety. They have to issue the certificate. Otherwise, I will not be entitled to get security deposit. No issue of substantial. This word has been imported where from, I don't know. Then 32. In so far the argument of the respondent that the claim to refund of the security deposit is premature, we find from the material on record that the work was completed in several phases. No phase for which the completion certificate was issued at different stages. Single certificate has been issued after completion of the work. Moreover, since the work was substantially completed, once again substantially completed, the claim of the refund of the security deposit was justified. So, my lord, on a erroneous understanding, the Honorable Single Judge has on an erroneous understanding that there are different phases, different, my lord, completion certificate would be there. I have completed 2 phases, 3rd page I have not completed. This erroneous understanding, this observation has been made. Then, my lord, interestingly, page 10. Paragraph 32. Another aspect of the matter ought to be considered. Clause 3. In the subclause A, B, C provided different alternative measures which could have been taken by the respondent in case of the non-completion of the work by the claimant. Since the respondent has invoked 3C, there is no invocation of single evidence. 3C by awarding the work to the second contractor. It is not ipso facto, mirror, only giving the work ipso facto does not mean that the invocation of the 3C would be there. Certain preconditions are required to be adhered to. Which precondition never been adhered to? No evidence at all. It would be entitled to forfeit the security deposit as well. Such approach would defeat the claim of the risk and cost expenses made by the respondent in the counterclaim. Last through line. The arbitral tribunal cannot be faulted by directing refund of the security deposit to the claimant while granting the risk and cost expenses to the respondent. This is completely erroneous observation, completely misunderstood, and my lord did not construe the clauses of the contract. Then, my lord, whether the compensation can be awarded, which is against me. Whether the compensation can be awarded to the respondent risk and cost principles. See, my lord, page 11. Page 11, the first paragraph, last 2-3 lines. And as such, the respondent authorities acted well within its jurisdiction to invoke the clause 3C on the principle of the risk and cost liability. Non-imposition of the penal measure is thus a non-issue to the contest. That means liquidated damages. I am faulting. No, there is no liquidated damages. One fine morning, they are writing me a letter saying that your work will be terminated on such and such date. Although I am lagging behind since long back. No liquidated damages. Then, my lord, paragraph 40. However, the remedy of the refund of the security deposit under the contract is independent of the claim of the risk and cost compensation. Where from, my lord, this concept comes, my lord, I don't know. In any event, clause 3, any of the alternative measures under subclause A, B, C could be invoked, correct? Even if the security deposit was not forfeited under clause A, but the directed to be refunded, the same could not be sufficient ground to defeat the claim of the risk and cost. My lord, this is contrary to the clauses of the contract. The claimant thirdly argues that the work awarded to the second contractor was on March 3, 2016. That 6 years after the completion of the claimant's work on 2010, thus the work was not a new project, unconnected with the work awarded to the claimant. I have shown the nomenclature is different. I have shown the BOQ is quite different. If suppose there is a work has been measured, 10 number of the BOQ. I did 7 number of the BOQ. 3 BOQ is remaining left. Only 3 number of the BOQ would be given to the X. If additional 2 item would be there, the work would be a new work because the calculation could not be done. This is the basic, my lord, the fundamental of risk and cost principle. Paragraph 42. This is also without there being any basis. Yet such argument is mutually contradictory, since the respondent argument of the limitation of the claim of the refund of the security deposit is registered by the claimant on the ground that the final bill was passed on May 18, 2016. It is evident that the work was not completed at this juncture when the second contractor was awarded the balance work on March 3, 2016. 43. Furthermore, from the both the measurement books and the letter written by the claimant itself, it is evident that the total work awarded to the claimant contractor was not completed. Fine. Hence, the respondent was justified under clause 3C of the conditions of the contract. You kindly take a note of it. Measure up the work of the contractor and to hand over the unexecuted portion of the work to the subsequent contractor. The material on record sufficiently so. Where is the material? This material is not there that the work has been measured up and the unexecuted portion has been earmarked. But the Honorable Single Judge has categorically held that the material on record sufficiently so. This is completely erroneous observation and based on no evidence, this observation. That the measuring up of the work was done by the respondent and as such the award of the work of the second contractor attracted the risk and cost principle under the clause 3C of the conditions of the contract. So, my lord, these observations are completely contrary to the clauses of the contract. Only, my lord, I will show single one clause that what is the provision of the extension of time. If the extension of time would not be there, subsequently the subsequent letter is completely osseous. Whether I have written or they have written under the erroneous impression. The legal effect of all those letters is completely nullity because that has been issued after the completion of the subject work when the contract was not alive. Milord, and then the third issue which has been mentioned, there is no, Milord, the quarrel with the proposition. Gayatri Balaswamy has categorically stated that the order can be modified and the Hakim's judgment has already been upheld to that effect, that computational error or if there is any minor error that can be, Milord, modified. So there is no quarrel so far as the computation error, all those things are concerned. I am on the basic principle of the awarding counterclaim, not on the computational, so computation is concerned. Volume 5, page 607, that is EOT, extension of time.
Yes.
Page 607, clause 5, volume 5.
Yes.
If the contractor shall desire an extension of the time for completion of the work on the ground of his having been unavoidably hindered in his execution, the contractor shall give an immediate report of the such hindrance to the executive engineer, authorized officer in the writing, and if he shall desire an extension of time for the completion of the work on the ground thereof, he shall apply in the writing to the executive engineer, authorized officer within 7 days from the date of the cessation of the such hindrance, on account of which he desires for the such extension as aforesaid, an executive engineer shall, if in his opinion and shall be the final and the reasonable ground has been shown thereof, authorize the such extension of the time, if any, as may in his opinion be necessary and the proper. So there is no provision on the basis of my prayer, extension can be allowed by the executive engineer. There is no provision for the unilateral extension of time. The principle of the, Milord, extension of time itself a contract. If I propose in that event, they will allow. So in the instant case, Milord, the subject project was commenced on 15th of February 2009. The total period was 180 days. 180 days has been extended by, Milord, subsequent extension. That, Milord, subject project completed on 24th of September 2010. Thereafter, three defect liability period, 3 years defect liability period, that would be end on 23rd of September 2013. So 23rd of September 2013, thereafter, there is no existence of a contract. Since there is no existence of a contract, I am entitled to get refund of the security deposit. Even I am entitled to get every after 1 year 30% of the security deposit. So it is my respectful submission. And I will place, Milord, one decision. It is your, Milord. So, Milord, I am not placing Gayatri Balaswamy, only I am placing, Milord, associate builders, only few paragraphs. Paragraph 28, Milord. Associate builders. In the, Milord, may I? 28. Milord, may I? In a recent judgment of the ONGC Limited versus Western GCO, the court has added the three of the distinct and the fundamental juristic principles and the which must be understood as the part and the parcel of the fundamental policy of the Indian law. The court held what is then would constitute the fundamental policy of the Indian law is the question, and the decision of the ONGC and that does not elaborate that aspect. Even so, the expression must, in our opinion, include for the such of the fundamental principle as providing the basis for the administration of justice and enforcement of the law in this country. Without meaning to the exhaustively enumerate the purpose of the expression of the fundamental policy of the Indian law, we may refer the three distinct and the fundamental juristic principles that must necessarily be understood as part and the parcel of the fundamental policy of the Indian law. The first and the foremost is the principle is that in every determination, whether by a court or an authority, that concerned is bound to adopt what is the legal parlance, my lord, so far as the judicial approach is concerned. In Sangong, that is not there. So far, my lord, I will not place. Then paragraph 38, internal page 38. Equally important and indeed the fundamental to the policy of the Indian law is the principle that the court and so also the quasi-judicial authority must, while determining the right and obligation of the parties before it, do so in accordance with the principles of the natural justice. Beside the celebrated ad alteram partem rule, on the facet of the principles of the natural justice is that the court and the authority deciding the matter must apply its mind to the attended fact and circumstances while taking the view on one way and the other. Non-application of the mind is a defect and is a fatal for any adjudication. Application of mind is best demonstrated by the disclosure of the mind. Disclosure of the mind is best demonstrated by recording of the reasons in support of the decision which the court and the authority is taking. The requirement that the adjudicatory authority must apply its mind is, in that view, so deeply embedded in our jurisprudence that it can be described as a fundamental policy of the Indian law. No less important is the principle now recognized as the salutary juristic principle fundamental in administrative law, that the decision which is perverse and so irrational that no reasonable person would have arrived at the same will not be sustained in a court of law. Perversity and irrationality of the decision is tested on the touchstone of Wensbury principle of reasonableness. The decision that falls short of the standard and the reasonableness are open to challenge in the court, law often of the jurisdiction of the superior courts, but no less is statutory processes whenever the same are available. So, my lord, in the given situation, both cannot be done together. So, it is shockingly, my lord, shockingly unreasonable and irrational. If I am entitled to get security deposit, it have to be construed that the subject project has been completed. If I fail to complete the subject project, I would not be entitled to get security deposit. If that be the so, there is no existence of a 3C. If the 3C would be there, subject project would be terminated, that would be measured and that would be given. There is no single evidence, neither the Honorable Tribunal hold in my favor, holding that no, the subject project has been measured and all everything has been done. And erroneously, Honorable Single Judge also has taken the similar approach which have been adopted by the Honorable Trial Court. By holding that both things can be done, you would be entitled to get security deposit. At the same time, you would be obliged to pay the counterclaim also. Then, paragraph 31. The third juristic principle is that the decision which is perverse and so irrational that no reasonable person would have arrived at, and the same and the important and the request some degree of the explanation, it is settled law where a finding is based on no evidence. There are the ample scope. I have cited few areas and few observations of the Honorable Tribunal where from it appears that although there is no evidence, certain observations and inference has been drawn. Complete bereft of any merit. Then, my lord, I will not place 2 Roman 2, I will place 3. Ignore vital evidence in arriving at his decision. So, the document I have shown in a particular way that, my lord, in running account bill and the completion certificate and other accompanying documents I have shown, that has not been considered. There is no reflection, neither in the Honorable my lord Single Judge has considered all those aspects, not the tribunal has considered all those aspects. Then, my lord, I am referring 42.2. The contravention of the Arbitration Act and the would be regarded as a patent illegality. For the example of the arbitrator gives no reason for the award on the contravention of the section 31(3) of the Act, and the award will be liable to be set aside. 42(3). Then, my lord, the quoted 28. Just I am, my lord, reading that portion only. In all cases, the arbitral tribunal shall decide in accordance with the terms of the contract, shall take into account and the usage of the trade applicable to the transaction. So, Honorable Trial Court has failed to consider the usage of the trade, in what circumstances risk and cost principle would be applied, and what is the procedure to be followed for applying the principle of the risk and cost. The last contravention must be understood with the caveat: the arbitral tribunal must decide in accordance with the terms of the contract, but if the arbitrator construe the terms of the contract in a reasonable manner, it would not mean that the award cannot be set aside on that ground. So, my lord, the reasonability is the basis, and in all the, my lord, the paragraphs I have intended to demonstrate that, my lord, that if there is any unreasonable understanding, unreasonable observation, and the, my lord, the which has been deduced by the Honorable Trial Court, and that cannot be said to be correct. So, my lord, I am not multiplying the decision, because this decision has considered the other decision also. And since, my lord, so far as the awarding and the computational error or something else, an impression has been given by the Honorable Single Judge and saying that this is a computational error, we have corrected it. Therefore, there is no difficulty. Therefore, no interference is required to be warranted. It is not correct. Principally, my argument has been recorded in toto. There is no difficulty. But wherefrom it appears that, my lord, the change of or any computational error, any modification, that will not, my lord, suffice the purpose. Only thing, principally, I have challenged the propriety of the awarding the counterclaim. That is, my lord, sum and substance, and my learned.
You will continue till recess, Mr. Dey? Or maybe not, you will. Then we can release everybody till recess.
Or, my lord, I can come back tomorrow also if your lordship.
No. Continue. Mr. Dey, just please keep in mind you are arguing a Section 37 appeal.
Yes, sir.
The award is not under challenge before us.
But in fact, my lord, there is a judgment.
Is the order of the learned single judge.
There is a judgment also reported in 2019 4 SCC 163, my lord, which clearly says, my lord, that the court does not sit in appeal, and also, my lord, that my lord, the interference in section 37 is also, my lord, akin to section 34. My lord, because my lord is aware that in 34, the scope of interference is very narrow, and my lord, in 37 also it is as permitted in section 34.
If not narrower.
Yes, my lord. Yes, my lord, my learned senior friend has relied on. My lord, I'll give that judgment. I'll give that judgment. But may I give it now, my lord, or I can put
Which
it in
one?
the note?
Which one?
MMTC versus Vedanta 2019 4 SCC 163.
On what point?
My lord, that
Scope of section 34.
Scope of section 34. Para 11, my lord, and 11, 12, 14. 11, 14. 11, 12, 14. My lord, if I may read 14, my lord.
Yeah, we've read it. Read it. Absolutely right.
Lord, here they have relied upon that measurement book saying that the work was completed on 24th September 2010. Date of completion and date of measurement. My lord, and also he has relied upon the certificate. My lord, admittedly, that certificate is of dated 16 July 2015. My lord, the measurement and the certificate was given on 16 July 2015. My lord, what is important is
Please, is your microphone working? Maybe not.
it is on, my lord, but maybe
No, take the other one. Take this one. আরে এটা কোনোদিনই কাজ করে না, এটা বলো রোজই এই প্রবলেম।
Can you hear me now, my lord?
Yes.
Now, my lord, that the date of completion, 24th September 2010, is disputed by the fact that, my lord, there are contemporaneous letters, which my learned senior friend has also shown, later dated 13 December 2011, 2010, 5th January 2011, 9th February 2011, 1st March 2011. All these are contemporaneous to the date, which is of 24th September 2010. Now, my lord has seen the learned arbitrator, and also, my lord, the learned single judge has held that the work was not complete, which, my lord, the finding has really come with the effect with upon considering, my lord, the contemporaneous documents on record. Now, my lord, I'll not waste your lordship's time by referring those letters again. Your lordship has seen those letters. And what does he say? He replies to those letters. What does he say on 7th March and 29th March? He doesn't say that you have already measured the work, you have already given the certificate, that it is complete on 24th September 2010. He cites various reasons and say that I cannot work any further. So, my lord, the answer, the reply to those letters will clearly demonstrate that work was not complete for whatever reasons, my lord.
Mr. There are three issues which the learned single judge framed.
Yes.
Two of them have been answered in your favor.
Yes, my lord.
Number 2 and 3.
Yes.
One has been answered against you.
Yes.
So your challenge should be limited to that security deposit.
Yes.
Are we correct in saying so? So what is so wrong with the learned judge's approach? Because your claim on account of risk purchase has been allowed.
Yes.
Not only that, the computational error which was corrected by the or which was not corrected by the tribunal
Not corrected. Not
has been
that
corrected
was
by the
correct.
learned judge.
Yes. Yes.
Right. So you can't have it both ways, can you? I will not give back the security deposit also, and also I will invoke the risk purchase. So the learned judge has taken this view. They are independent things, measures. You are not.
My lord, may I put it in this way? My lord, the forfeiture of security deposit, my lord, kindly appreciate. The clause says I can forfeit the security deposit. Now, I'll also place on record 3C is an independent clause, and 3C also mentions about forfeiture. It's not about only 3A mentions it. because learned single judge has held that 3C was not invoked. The learned arbitrator has also held 3A was not invoked. So I cannot claim for forfeiture. But my answer to that is that 3C also contemplates a situation of forfeiture of the security deposit. It's an independent clause.
Where are these 3A, 3B, 3C?
Yes, madam. My lord, the award is legible. I'll show from the award.
Sunday 4, volume 5.
Yes.
I will kindly take clause 3 first. Lordship has it? 6. In any case in which under any clauses of this contract, the contractor shall have rendered himself liable to pay compensation amounting to the whole of his security deposit, whether paid in lump sum or deducted by installment. The executive engineer authorized officer on behalf of the authority shall have power to adopt any of the following. The Lordship has it? Any of the following courses. So, my lord, it's not that entire 3ABC I have to invoke. Any of the following courses as he may deem best suited to the interest of the authority. Now, my lord, what does A say? A says that there has to be a termination.
Yes.
To rescind the contract, and in which case the security deposit of the contractor shall stand forfeited and be absolutely at the disposal of the authority.
Yes.
And my lord, 3C, if your lordship has seen last 2 lines, under the contract or otherwise, or from his security deposit, or the proceeds of sale thereof, or a sufficient part thereof. So, my lord, my first argument was that he is not entitled to the refund of security deposit. Why? Because admittedly the work was not complete, and second, that they did not maintain the roads, because they had to maintain the roads for 3 years. And my lord has seen a clause that the refund was on a staggered basis. The first year 30% will be refunded, second year another 30%, third year 40%. Now, my lord, there is a letter of 4th May 2015 which categorically says, their letter, my lord, Clement's letter, that the person concerned was not available because he met with an accident and he had to leave the work as his various basis. He could not, no one from his office could contact, neither any work could be done. So, my lord, these evidences have been considered by the tribunal. And upon considering these evidences, it was held that the work was not complete. Now, my lord, that is where I join the issue, my lord, that having said so, the refund, that is why, my lord, I filed an appeal, that having said so, my lord, the refund of security deposit could not have been allowed. And ultimately, sir, my lord, although it has been allowed, my lord will see that it has been adjusted, because my counterclaim is much more than the, so the tribunal has allowed an adjustment.
So why are you trying to be Shylock?
No, my lord, I am not trying to be Shylock.
No, we understand public
I have not
authority
challenged
will
that. I have not challenged that part. I have not challenged that it should not have been adjusted.
No, you have challenged that part, the award of
because my lord will
refund
kindly
of
appreciate that if my argument so far as 3C concerned goes, then my lord, the refund of security deposit, the award of refund of security deposit will remain. Because my lord, my first argument is that security deposit could not have been allowed to be allowed.
We have
Because
followed.
completely, admittedly, he could not complete.
Yes.
So, my lord, in my appeal is the next matter where I have dealt with is the first part of refund of security deposit. So, my lord, I'm not coming on that as of now, because I have to reply to that 3C part which they have argued. which is the subject matter of the first matter challenge. So I'm on that, my
No,
lord.
don't worry on that.
Okay.
You concentrate on your refund of security deposit only, because you are agreed only with that.
Yes, my lord. But my lord, I have to address his contention so far as his appeal is
I'm
concerned.
telling you, you need not.
My lord, then kindly come to the impugned judgment. Para 20, my lord, are the issues. Para 22.
Yes.
My lord, para 22, it is stated the respondent has argued that the claim for refund of security deposit is barred by limitation. Because, my lord, I had made an alternative argument that even if the learned arbitral tribunal holds that I have to refund it, then, my lord, my alternative argument was that you cannot pass that award because it is barred by limitation. Why I say so? My lord, I had said so because taking their argument that the contract was completed on 24th September 2010. Now, my lord, will kindly see the contract says that first 30% will be refunded upon completion of 1 year from the date of completion. So, my lord, if 24th September 2010 is the date of completion, then 1 year ends on 23rd September 2011. So, my lord, for that 30% limitation 3 years, which ends on 23rd September 2014. Likewise, my lord, all the installments which they are entitled to ends on 23rd September 2016. Now, my lord, admittedly, the arbitration was invoked on 13 December 2016. So, my lord, that is why we argued that it is barred by limitation.
Yes.
So, my lord, what the learned arbitrator has held, learned arbitrator did not consider that clause at all. Learned arbitrator says that 3 years you have defect liability period, so it ends on 1st March 2014, and 3 years from there, which is 1st March 2017. So the invocation is of 13 December 2016, so it is within the limitation period. Now, my lord, to that, what the learned single judge has held, para 22, it says, my lord, the respondent has argued that the claim for refund of security deposit is barred by limitation. However, such contention is contradictory with the argument of the respondent itself. On the one hand, the limitation ground is taken on the premise that the work was completed in the year 2010, but the claim was made only in 2016. Well, this we have said basis their case. They say that work was completed on 24th September 2010. Now, the second part, and on the other, the respondent argues that the claim for refund of security deposit is premature.
No, why do you, Mr. Dev, why are you saying they say? Didn't Mr. Dotto show us some certificate issued by your officer?
Yes, my lord, that is what I started with.
Yes.
That measurement book which they rely upon.
Yes.
The certificate is of 16 July 2015.
Yes.
Which says that date of completion of work was 24th September 2010.
Correct.
Now, my lord, to that we had argued that date of completion means that till date the work which was done by the claimant, because the contemporaneous letters will show that the work was not complete. Because your lordship will remember.
Was that certificate issued in connection with the final arrangement?
Whatever work, because my lord, your lordship has seen a letter of 2015 also, where we again tell them, then ultimately they say that we can't do anything. We have done whatever it is, so you close it. Then ultimately on July 2015, that certificate was issued and the final bill was also drawn, because your lordship will kindly appreciate that this measurement has to be taken, then the final bill has to be drawn and then ultimately paid. So it was paid in May 2016. So that is also the date which my learned senior friend had argued that the limitation stood extended because the final bill was paid on 18 May 2016. Now, my lord, there also, my lord, if I am permitted to argue this, that 2010, because their argument, 2010 the work was completed. Now, any payment made in 2016, your lordship is aware, section 18, whether it will give a fresh cause of action, because it is after 3 years. The payment was made after 3 years. That also, the deduction was only for 50,000 rupees, 57,000 rupees. Whether that can give again a fresh cause of action.
The highest error of law. The highest error.
The measurement was done in 2015, that means.
Yes, my lord.
Then how can it be
But
barred?
he is harping on, my lord, it is said date of completion is 24th September 2010.
Maybe, but measurement,
Hmm.
if the measurement is done on a particular day, that can give rise to a cause of action. Doesn't it?
My lord, that is relating to the fourth bill. My lord will kindly appreciate the security deposit is deducted from each bill.
Provided that an award shall not be set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. Parliament says so. Even assuming on the point of limitation, the arbitrator and the learned single judge erred. Your argument. Difficult. Anyway, you make your argument. Please try to complete today because we have devoted substantial time today.
My lord, para 22 as placing, it says on the other, the respondent argues that the claim for refund of security deposit is premature as the 3-year maintenance period after the completion of the work has not elapsed after the final bill was raised in the year 2016. My lord, I had argued on two different aspects because firstly, they say that the work was completed on 24th September 2010. So assuming but not admitting that that was the date, then my lord, the contract provides that upon completion of the work, how that security deposit was to be refunded. So my lord, taking that cue, letter of invocation of the arbitration was in 13 December 2016, so it was barred. Thereafter, my lord, the second argument that if that argument is also not considered, taking their point that it was done in the final bill was raised in the year 2016, then my lord, I had argued that if my final bill was raised in 2016, then the defect liability period did not start because the final bill was paid in 2016. So in both the events I have argued, my lord, that is reflected here. Now, my lord, secondly, para 24, the next objection taken by the respondent to the claim of the refund of security deposit is premised on the ground that the claimant did not complete the work awarded under the concerned contract, and as such, clause 3A of the condition of contract could have been invoked, thereby forfeiting the security deposit. Now, my lord, here 3A was not invoked because termination, the arbitral tribunal said there was no termination. Although we had argued that 1st March to 2011 letter said that this will be the last letter. Your lordship will remember, we have given them 7 days notice and no further correspondence, it will be terminated. So although we had argued that the contract was terminated, but the arbitrator held that no, the contract was not terminated and 3A was not invoked. Now, my lord, para 26. Para 26 also I have not challenged here because it says that there is nothing on record to indicate that the contract was rescinded, because I have not challenged that part in the 34, so I am not on that. because I say, my lord, that 3C is independent, where I could have forfeited the security deposit. 27, on the contrary, instead of terminating the contract, the respondent went on passing bills till the final bill on 18 May 2016 and continued to make payment. 28. Secondly, completion certificates were issued from time to time. Thus, the respondents stopped from arguing that the entire work was not done, only in which case the security deposit could have been forfeited. Now, my lord, I am also not on that. Para 29, the letters issued by the claimant, which are sought to be relied on by the letter, were only restricted to a part of the work having not been completed. However, the measurement book, which are documents admitted by both the parties, clearly indicate that a substantial portion of the work was actually completed and final bills raised. Hence, clause 3A of the conditions of contract could not be invoked at all. Now, my lord, again I say that even if 3A is not invoked, under 3C I was entitled to forfeit. Now, my lord, kindly see clause 33, para 33. Another aspect of the matter ought also to be considered. Clause 3 in subclauses A, B, and C provides different alternative measures. So, learned single judge also appreciates that clause 3 in subclauses A, B, and C provides different alternative measures which could have been taken by the respondent in case of non-completion of the work. Since the respondent has invoked clause 3C by awarding the work to a second contractor, it cannot be said that it could be entitled to forfeit the security deposit as well. So, my lord, here I am saying that clause 3C refers to forfeiture of security deposit also, because the finding is it cannot be said that it would be entitled to forfeit the security deposit as well. However, my lord, what I have argued before the learned arbitrator, that why it is barred by limitation, that the learned single judge has not dealt with. Because, my lord, I've just said that before, that their case is that completion is of 24th September 2010. The contract, my lord, may I show the clause? Your lordship remembers that the security deposit will have to be refunded on a staggered basis.
30, 30, 40.
Yes, my lord. So, my lord, admittedly, by seeing that, your lordship will appreciate that it is barred by limitation, because admittedly the invocation was in December 16. My lord, what they argue is that final bill was paid in 2016, even if I take that measurement was done in 2015. Still, my lord, the first 3 bills, the security deposit were deducted from that first 3 bills. And also, my lord, there is a finding that of the learned single judge, that the security deposit was demanded in 2016. That is also, my lord, incorrect on the record itself, because in 2011 only they have asked for the security deposit. So it's not their case that the security deposit amount was demanded in 2016. So in 2011 itself, they have demanded the security deposit. My lord, may I show that? Para 23, the learned single judge has mentioned the claim for refund of security deposit cannot be held to be barred by limitation, since the final bill was admittedly prepared and passed only on May 18, 2016. Whereas the claim for refund of security deposit was made on November 11, 2016. So, my lord, this is an incorrect finding, because from the record it will show that they have sought for the refund of security deposit in 2011 itself. So, my lord, the payment of final bill in 2016 will not give them any fresh cause of action for the amount which have already been deducted. Because in 2016, I have deducted 57,000. They can at the highest say that, okay, my limitation starts from that day so far as 57,000 is concerned. But the maximum chunk of 15 lakhs, which was deducted in 2010, that, my lord, perhaps cannot be asked in 2016.
Roughly, we are not rushing you, Mr. Day. Roughly, how long you will take just to assess our.
My lord,
you're almost through. You've indicated your point.
yes, my lord. Well, I've indicated my points. So far as the calculation part is concerned, they have not made any argument.
No.
So
Mr. Dattu fairly says that that power he had, computational error.
I should take maximum 30 minutes.
30 minutes.
Maximum.
Come back at 2 o'clock. Finish it off.
My lord, has 638. Now, my lord, kindly see para E. This, my lord, C refers to that question 105-104 relating to bill of quantity. In cross, RW1 admitted that in the said bill of quantity, the third contractor did additional work in respect of item number such and such. I have perused exhibit such and such and found that there is omission of any amount payable. So, in my view, the total amount of such additional work is calculated at rupees 11 lakh. So, my lord, my entire claim was not allowed, which amount cannot be claimed from the first contractor, as those items were not included in her bill of quantity. Though a total amount of 73 lakh was paid to the subsequent contractor, the said excess amount of rupees 11 lakh will have to be deducted from such total payment. Thus, it appears to me that the second contractor did the work amounting to 61 lakhs. So, my lord, no suggestion was given to my witness that the second contract did not pertain to any balance work or unfinished work. Specific question was put that what are the additional works? And that was considered, my lord, by the learned arbitrator. So, my lord, so far as the finding of the learned single judge with regard to 3C, my lord, I humbly submit, my lord, there is no infirmity, so that your lordship can interfere in that part. And with regard to the refund of security deposit, my lord, I say that it is apparently, my lord, the contract says how it has to be released. So, my lord, the finding of the learned arbitrator is contrary to the terms of the contract, which is also, my lord, a ground for setting aside. My lord, on facts, my lord, I'll file my notes if your lordship requires. My lord, only 24, 25.
Not necessary, Mr. Day. Not necessary. We have made our notes.
But only one judgment. I just want to rely on the scope of interference, my lord. 2019-20 SCC 1. My lord, maybe the marked copy has gone inadvertently.
No problem. I prefer marked copies.
My lord, 24 and 25.
Paragraphs.
Yes, my lord. Page 12, my lord. There is no dispute that section 34 limits a challenge to an award only on the grounds provided therein or as interpreted by various courts. We need to be cognizant of the fact that arbitral awards should not be interfered with in a casual and cavalier manner unless the court comes to a conclusion that the perversity of the award goes to the root of the matter without there being a possibility of alternative interpretation which may sustain the arbitral award. Section 34 is different in its approach and cannot be equated with a normal appellate jurisdiction. The mandate under Section 34 is to respect the finality of the arbitral award and the party autonomy to get their dispute adjudicated by an alternative forum as provided under the law. If the courts were to interfere with the arbitral award in the usual course on factual aspects, then the commercial wisdom behind opting for the alternate dispute resolution would stand frustrated. Moreover, umpteen number of judgments of this court have categorically held that the court should not interfere with an award merely because an alternative view on facts and interpretation of contract exists. The court needs to be cautious and should defer to the view taken by the arbitral tribunal, even if the reasoning provided in the award is implied, unless such award portrays perversity unpardonable under Section 34 of the Arbitration Act.
That is all. We'll reserve the judgment then?
Only one line, my lord.
Yes.
The power which has been, my lord, mentioned in the section 34 is the coterminous with the section 37. Your lordship sitting in the or in exercise of the power under section 37, your lordship can exercise the jurisdiction vested under section 34 also.
My lord, also, my lord, I'm sorry, my lord. In the next matter, I had filed a GA. I had a 16 days delay, my lord. The
Which
GA1,
matter?
GA1, my next matter. My lord, where I am the appellant.
8 and 9.
In your appeal.
In
your appeal.
There is a GA, my lord, for condonation of delay.
We are hearing these two appeals together.
Yes.
Right. তুমি ওই জিএটা নিয়ে আগে করো, হ্যাঁ? This is an application for condonation of delay of 16 days.
16, my lord. 16.
16 days in presenting the appeal. Stop. Causes shown being sufficient, the delay is condoned. DA is disposed of. করে এবার appeal দুটো নাও আলাদা করে নিয়ে বলো, we have heard learned counsel for the parties at length. Stop. Hearing is concluded. Stop. Judgment is reserved.
Grateful, my lord, for being so patiently. Yes.
Appeal from decree. Item number 10.
কি বাবা কেউ নেই তো, কেউ না, কি আশ্চর্য।
Appeal from orders. Item number 11.
না কেউ না থাকলে pass
My lord, I
করতে হয়।
appear for the appellant. The
Yes.
respondent was here. I appear for the appellant, my lord. This is
Who
that
appeared?
section 37 appeal, my lord, of 2010, my lord. I was addressing, my lord.
Yes, we are hearing you.
Yes, my
Who
lord.
was on your other side?
She was here. First half, she was here throughout, my lord.
You want to, we'll pass it over, we'll run through the list once.
My lord.
If you can contact her,
I'll do that. I'll do that. I'll call her. Okay.
পুরো লিস্টটা দেখো একবার।
Lord, item number 12, I appear on behalf of the appellant. Mr. Mitro had already, these are those,
Yes, yes.
the Mr. Sabyasachi Chaudhary, learned senior advocate, he was arguing. He has commenced his submissions on the last occasion. We are
Pass over.
Item number 13 and 14.
I am for the respondents in this.
Your Lordship, I appear for the.
চলো pass.
15 and 16. Item number 17.
Item numbers 15 and 16, my lord, I appear for the respondent. And in
17 and
15 and 16, my lord.
yes.
As per the last order, my lord, dated 4th August 2025, brief notes were directed to be filed. Appellant is Union of India.
What was directed to be filed?
Short notes of argument, my lord.
Notes of argument.
Yes, my
কি
lord.
order আছে দেখি? মনে হচ্ছে। Supplementary. Which means supplementary filed. Yes, we have oh.
There is also a cross appeal, my lord, in item number 16.
Pass it over, madam.
17.
Lord, I am for the.
Second call. Appeal from degree. Item number 10.
Lordship, in item number 10, I am paying for note today, your Lordship. It can be kept on next Monday, your Lordship, because commercial matter generally, your Lordship keeps on Monday and
Right.
Friday. But this Friday, Mr. Bagh will not be available, your Lordship. In that case, next Monday, 25th.
He is your counsel.
He is my counsel, your Lordship.
On the prayer made on behalf of the appellant, let this matter stand adjourned for the week.
If you are blessed. Date হচ্ছে 25 August. মানে এই week-এর একদিন।
Item number 11. Second call.
I tried calling her up, Miss Orijita Ghosh. There here. So I can start.
But on the last occasion, I was addressing, my lord, on claim 1.
You have filed a note.
2 notes I have filed covering my points in effect, my lord. That's why I'll just run through the note only, because this is a works contract related dispute. An award passed against me, my lord, in my humble submission, ex officio contrary to the terms of the contract. And this, my lord, will kindly bear in mind, which I have my lord, submitted on prior occasions. I'm sorry.
That
On
polls or something.
polls is claim 1. There are several claims, each relating to a different element of work. Claim 1 is the claim which is discussed at length by the arbitrator. And the reasoning there is flawed, as I've tried to establish before, my lord. On the ground, my lord, the notes, my lord, I'll refer to. I'll just give, my lord, the brief overview. Claim 1 relates to corrective measures in placement of polls done by the contractor, my lord, where it's an admitted position, and that's the finding of the arbitrator that the polls were incorrectly placed. In the sense, the polls, my lord, once they're placed incorrectly, my lord, the geometry of the polls is incorrect. That's visible from the ground level. This is supposed to be an item which is mostly underground. What happened here was the poles were placed in such a manner that the heads of the poles were piles, rather, not poles, not piles. Well, the heads of the piles were visible from the ground level. Therefore, it became apparent that there has been incorrect placement of piles, and that's an admitted fact. That's not disputed at any time. The arbitrator also holds that. What the arbitrator goes on, and which in my humble submission, my lord, could not have been held by the arbitrator, is that as per usage, this is the term used, my lord, will kindly bear this in mind. The arbitrator holds as per usage, placement of piles is at the express instruction of the employer. Therefore, the arbitrator says that if it was as per my instructions that the poles were placed, I could not thereafter have gone and said that these poles are incorrectly placed, though the fact that they were incorrectly placed is admitted. Now, what I am endeavoring to, my lord, submit before my lord is the contract specifically provides for 2 things. Number 1, the contract contemplates a drawing that is submitted, a drawing pursuant to which, my lord, the contractor has to carry out work. Number 2, the contract envisages that if there are incorrect placement of piles, no matter what, my lord, the contract does not go into attributability of that, or rather at whose fault those incorrect placements are made. The contract says if incorrect placement of piles, then corrective measures are to be done, and no payment will be disbursed in respect of such corrective measures. Now, my humble submission is, my lord, once the arbitrator holds that these additional piles were installed as corrective measures, and that's the word used, corrective measures, no payment could have been made under the terms of the contract. And this is pre-2015 amendment, my lord. The arbitrator could not have gone into usage at all. The arbitrator was bound by the terms, express terms of the contract and the contract alone. That is the sum and substance of claim 1. My lord, the contractual clause last occasion I had placed.
Mr. Mukherjee, just 1 minute.
Yes,
Mr. Banerjee, that Praveen Kumar ITC matter.
Yes,
We were wondering why should we keep the stay application pending? Why don't we dispose it off and include a copy in the, in the informal paper book? That's the for reference. Somebody should come so that, yes.
I'll just tell you.
Otherwise, we did not indicate that we want to dispose of. So it will be only fair if he takes the trouble of coming once, so that I can tell him also, either Mr. Bose or Mr. Shomura Choudhury.
Yes, I'll just.
Thank you.
My lord, if my lord has my note.
Yes, yes.
I'm sorry. My lord, if my lord has my notes once, my lord, the first note that I had submitted, supplementary note, first, supplementary.
দুটো নোট বলছে কেন আবার কিছু নোট দিয়েছে?
Yes, Muller had granted me leave. I had filed a supplementary note only on a few additional points that I want to know. That's a very short note. Muller, note 1, Muller, claim 1 rather. It starts at page 2. I had taken Muller through the relevant portion of the order or the award. Muller, here the relevant clause that I'm referring to, Muller will find. Firstly, my lord, page 3, the underlined portion, my lord, will see the arbitrator's reliance. Page 3, my lord, has of the note.
E.
Well, page 3 of the note, well, this is a quoted portion of the award that's appearing at page 701 to 712 of volume 5. I've quoted out the relevant portion. Well, from the underlined portions, well, we'll find the two findings that I was relying upon in respect of my submissions. Number one, that usage is relied upon. Mulad, page 3, top Mulad, the underlined portion Mulad will see. In item rate contracts with employers' regular supervision, as per applicable usage, construction work so and so. I'm not placing it again. Mulad will see the arbitrator relies upon usage to come to his findings. And thereafter, Mulad, the second underlined portion, Mulad will find that discrepancies in pile gap geometry is admitted. I've underlined that portion. And thereafter, result, as a result, the sentence starting with as a result, pile number 1604 to 1622 were installed as corrective measures. Will kindly note the use of the word corrective measures. Therefore, these findings are of the arbitrator, not challenged by any party. This is the finding. Now, on this basis, the arbitrator goes on to award the costs, or rather the amount payable in respect of those additional 8 piles. The rest of the award is also quoted. I'm not bothering Malad with that right now. Malad will kindly come to page 4. Page 4, beneath the quoted portion, para 7. That's a part of my submission. That's not in italics. Page 4. Malad will see these are my submissions. That's not italicized. Where I say it, and I've taken Malad to that provision of the contract at page 88, which say that if a corrective measure is carried out by way of installation of pile or otherwise, I am not liable to make any payment to the contractor. Now that is my that is the sum and substance of my submission. Also, Malad, a couple of vital documents the arbitrator has ignored, or rather not construed in the right manner. Page 538, which is referred to in the award itself, page 538 I have taken Malad to. That is my letter specifically intimating the contractor of their default and the incorrect placement of piles. I have also written to them. It's not as if this is an afterthought. I bring up this issue only at the time of preparation of final bill. I bring this issue up right at the start. 8 January 2024, page 538. Well, that's part of volume 4.
Where is that referred to in your note?
That's referred to, Mulad. Mulad, it's part of the award. Mulad will see page 3. Page 3, Mulad will see part of the award. It's the quoted portion.
Yes,
right,
R96.
R96, yes. So arbitrator refers to this letter, but does not consider the impact of this letter. It's not as if this is an afterthought. Now, in my note, Malad, apart from 538, Malad, is just a simple letter of the engineer in charge.
So it's not that he did not consider.
No. He has misconstrued is my submission, or he failed to appreciate. It's not as if he did not consider. I bow down, Malad. He has considered it, but perhaps he's overlooked the impact of that letter. He's considered it by referring to it, but has not considered the impact. Now, Malad, one further letter, Malad, 7th September 2004 also, I've referred to in my note, page 5, that's at page 600. Indicate that. Page 600, Malad, that's volume 4, last page. Last page of volume 4. Malad, this is my client's letter specifically putting on record. This is 7th September 2004, when the contract was still subsisting. Malad has page 600, last page, second last page. Malad, here, this is my letter to Sifcon Construction, that's the respondent award holder. Malad will see the highlighted portion towards the middle. 18 numbers of piles which were executed in addition to the design number of piles as per the drawings for your wrongful placement of the piling shall not be paid. Should be as per the terms and conditions. I think as per the terms and conditions of the contract. So I write to them specifically, putting them on notice that no payment will be released in this regard. Therefore, it cannot be said that it is an afterthought, and this vital evidence, subject to correction by my learned senior friend, has been ignored by the arbitrator. The arbitrator has not considered this letter. Therefore, contractual terms read with my conduct also show that I have put him on notice of the contractual terms which he has agreed to and signed and never challenged, that he is not entitled to any payment in respect of these incorrectly placed files. Well, that's claim one. Claim one, that's about it. Well, claim 5, my lord, will kindly have. My note, if my lord comes back to page 5. My lord, this relates to additional boring work. Here, my lord, again, my case is that there is a contractual stipulation prohibiting this claim. This is an item rate contract with a specific schedule and rate of works. If X amount of soil is to be excavated or bored, and it turns out that he has had to bore X plus 10, he is not entitled to any additional payment in respect of this extra boring. That is the sum and substance of my case, and that I've referred to, my lord, the portion of the award I've referred to. I'll quickly take, my lord, through that. Page 5, if my lord has, of my notes. Contract stipulation of minimum pile length of 23 meters was changed to an average pile length of 22.151. My lord will note this change was never challenged by any party, while the length between the ground level and cutoff level increased from the stipulated 0.900 meters. This caused increase in the unpaid board length. My lord will kindly note the words used by the learned arbitrator. It caused increase of the unpaid board length vis-a-vis paid before the length, creating on additional work of considerable board length. The respondent has remained silent on this aspect of change in the minimum pile length. Considering all evidence, I accept the claim with the arithmetical correction, such as average board length, and then the arbitrator goes into an arithmetical calculation. This is not also as per the statement of claim. The statement of claim claims X, the arbitrator goes into an arithmetical deduction of the actual amount payable, which perhaps he is entitled to do. But my fundamental point is, my lord, I've referred to, my lord, two clauses. My lord will see after the quoted portion. It's a short portion of the award. That is the totality of the reasoning which I have quoted. That's it. Now, my lord will kindly see my submissions. The aforesaid findings are contrary to the contract terms, specifically clause piles, and under the heading contractors' rates are to include. My lord will see this is the contractual provision which says that the rates quoted by the contractor have to include XYZ. This includes piles, which includes payment as to boring in respect of installation of such piles. Of the technical specifications, so and so rates of piles was to be inclusive of the extra cost required for extra length of boring existing between the existing ground level and cutoff level. My lord, page 84, if my lord kindly has now, of volume 1. That's the contractual clause. I'll just very quickly indicate that. Page 84.
You had placed the entire note, Mr. Mukherjee. We find it's all marked.
My lord, it was heard at length before the prior bench. This bench, my lord, I'm having to, my lord, address afresh. No, my lord. Prior bench with just Chattopadhyay. It was, my lord, heard at length. I would not have trouble, my lord, with any further submission, but since this is a different bench, my lord, I have to refresh. My lord, page 84. Page 84, my lord, has piles. My lord, we'll see the bottom clause. My lord, we'll see the heading contractors' rates are to include. This is a part of the admitted contract between the parties. Piles. Unless otherwise specified, the rates of pile shall be quoted inclusive of concrete, labor, transporting components, so and so. My lord will kindly skip a few lines and go to, my lord, the sentence starting with the rates for the piles shall be inclusive towards the middle of the clause. I'll just place the sentence below. The rates of the piles shall be inclusive of the extra cost required for extra length of boring between the existing ground level and the cutoff level. For any variation of the number of piles, so and so, not relevant. Extra boring was specifically barred under the terms of the contract, or other payment as to extra boarding was barred under the contract. His rates, the contractor's rates, which were quoted during the time of inviting tenders, that was to be inclusive of everything. So thereafter, after having carried out extra boarding, to come forward and raise a claim that is contrary to the terms of the contract, that cannot be awarded by the arbitrator, who is again a creature of the contract in the pre-2015 amendment stage. My lord, claim 5, my lord. In essence, that is it, my lord. My lord, there's some further submissions, but really my submission primarily is on the contract. Therefore, this claim again is contrary, ex officio contrary to the terms of the contract, insofar as no extra payment is due and payable. Now, claim 8. Now, claim 8, my lord, this relates to welding of reinforcement bars, wherein the respondent, that is the award holder, had alleged that the appellant had instructed the respondent to spot weld. My lord, here I'll just indicate the case in brief, my lord, before taking my lord through the documents. My lord, a part of their contractual obligation was to put in a reinforcement cage. It was to reinforce the piles. That could be secured because it's a reinforcement cage. It had to be secured. So there are various methods of connecting the joints of that reinforcement cage. One of those methods is spot welding. Spot welding is a time-consuming and expensive method of reinforcing that cage. What the respondent award holder has alleged before the arbitrator and also continues here is that we had, or rather the employer appellant had directed the respondent to spot weld every single joint. That is why additional work had to be done. That is why additional claim, therefore pay me my additional pay. Our stand before the arbitrator and even in this appeal, my lord, is that we had never issued such an instruction. The contractual provision says that the reinforcement cage should be suitably secured. Something like that. The exact phrase, my lord, I'll place the contract specifically. It does not specify spot welding for every single joint. Now, if the contractor goes ahead and does something that is more expensive and that requires further work, that is at his own risk and peril, we cannot be made liable for that. That is the sum and substance of my case. The contract also, the clause is there. It specifically does not specify spot welding. My lord, claim 8, my lord. Will kindly have. My lord, may I just place the portion of the award very quickly? All the time for all the time should be at the time, my lord. I don't think that's correct. At the time of deciding on the claim, I have to consider the following aspects. A, whether welding of reinforcement cage as necessary. As necessary, that's the term of the contract being quoted by the arbitrator. And lowering of the reinforcement cage complete, as mentioned in item 1 of the price schedule of the contract agreement, together with the provisions of the technical specifications, so and so. As such, reinforcement used in cast in situ piles shall be made up into cages sufficiently well wired or spot welded to withstand the handling without damage, means that all intersections of the helical stirrups and main reinforcement are to be spot welded. This is the question that the arbitrator himself frames. Now, my lord, we'll see the arbitrator's interpretation. Page 8. My interpretation is, quote unquote, this is the provision of the contract being quoted, welding of reinforcement cage as necessary definitely does not mean all intersections of lateral and longitudinal reinforcement are to be spot welded. Specific finding that the contractual terms do not require spot welding at every single intersection. Specific finding. Again, well wired or spot welded to withstand handling, handling without damage in technical specifications definitely does not connote spot welding of all intersections. Considering everything, I state that the rate for item number 1 may be taken as inclusive of run weld of longitudinal reinforcement of cages primarily, together with the spot welding of a few of the intersections which may be affected by such handling. Such points were tying of lateral and main reinforcement may be affected with wires being torn, coming off, may be safely considered to be restricted to 5% of the points, approximately 60 points of the intersection to a pile of average length. The second aspect is the quantum of work. it may be stated that with certainty, the respondent never controverted that the work of spot welding at the intersections was done by the claimant. The claimant stated at the behest of the respondent, he had to undertake such spot welding at all intersections of all the piles, but the additional was not paid by the respondent, hence the claim. Will you kindly turn over? Well, the respondent took the position that this work of spot welding at intersections was included in item 1, but this letter of 25th June 2004 was written more than 2 months after the work was over, though the prayer seeking payment against this additional work for about 1400 piles was preferred on 21st October 2003. The claimant, after completing works in 1622 piles, again preferred the bill for this additional work on 14 June 2004, prior to the preparation of the final bill. This time the respondent reacted, as stated earlier, refer R116, that's the 25th June letter, which I'll take to. This time the respondent reacted as stated earlier, refer R116. In this letter, the respondent made, apart from the work being included in item 1, 2 additional remarks. Number 1, the claimant never instructed to do tack welding at every intersection. And number 2, the claimant did not tack weld every intersection. Now this letter, being R116 by the respondent, is full of contradictions. Firstly, if the specification of item 1 invites welding at all intersections, why was there no instruction from the claimant, from the respondent, to spot weld all the intersection points? Secondly, if they felt that there was no necessity for welding all the intersection points, why they did not keep a record of the number of points spot welded, as this was necessary for deriving the reduced rate of work? In short, the document is self-contradictory. Such a document, R116, was written after about a month of the total completion of the work, with which is inherently contradiction, hardly weakens the claim of the claimant. Hence, I accept the stipulation of the claimant that all intersections were spot welded at the behest of the respondent, in absence of any credible documentary evidence to the contrary. In sum and substance, the arbitrator holds that in absence of evidence to the contrary, I had instructed. The arbitrator holds, or rather holds the appellant before my lord to a standard of proving a negative. My cases I have never instructed. Arbitrator says, since there is no contrary evidence to show that you had not instructed, you have instructed. That is what this line holds. That is the specific finding of the arbitrator. Since I have not discharged my burden to prove, I have not instructed. How am I to instruct, or rather prove, a negative? The arbitrator proceeds fully on that. His specific finding is that I had instructed because I could not prove that I had not instructed. That is ex officio, my lord, contrary to law. There is no burden of proof. That's a burden of proof that is impossible for any person to, my lord, discharge. It's not possible. It's proving of a negative. My lord, on this basis, my lord, thereafter the prayer is allowed. My lord, 2 things here. Number 1, my lord, the arbitrator's own findings state that the terms of the contract are clear. The arbitrator does not hold that the terms of the contract are ambiguous. The arbitrator says that the terms of the contract do not require spot welding of every intersection. That's his finding. That's the first portion of the award which I just read out. Thereafter, the arbitrator holds that there is no specific evidence before the arbitrator to show that I had instructed. The arbitrator only says that there is no contrary evidence to show that I have not instructed. But that cannot be the basis of awarding a substantial claim of the claimant, where admittedly the item rate contract, the amount payable in respect of welding of the piles, is stipulated under the contract. The contract does not require him to spot weld. And my lord will recall the prior portions of the award. The arbitrator specifically says that in an item rate contract, everything is done under the specific supervision and instructions of the employer, that is my client. And thereafter, this finding is arrived at, which is ex officio contrary to the record. And it is it's a finding based on no evidence. taking my lord Q from associated builders. This is a finding on no evidence. Admittedly, no evidence. There is no positive evidence. There is no negative evidence. The arbitrator still holds, come to a categoric finding I had instructed. Now, my lord, my submissions are, my lord, I've made page 11 onwards, or rather page 10 bottom onwards, my lord, are my submissions. This is all I have to say, my lord. That portion, my lord, that clause which the arbitrator quoted as to reinforcement cage being welded as necessary, that's at page 84. Since the arbitrator has himself quoted, my lord, I'm not taking, my lord, to that again. My lord, thereafter, my lord, clause 16 of the conditions of contract, my lord, also provide that the consent of the engineer in charge has to be obtained for any work of this sort to be done by the contractor. Admittedly, as per the award, there is no such consent on record. Therefore, in any event, this work would have been outside the scope of the contract. If they've done so at their own peril, that's their prerogative. My lord, this, my lord, will kindly have a note. My lord, the page number is perhaps incorrect. My lord, it should be page 78, not 53, at para 13 of my note. This will be, my lord, page 78, not 53. My lord, if I may just quickly place page 78, clause 16. My lord, I'll just place very quickly, my lord. All works, my lord, the heading of the clause is works to be carried out in conformity with the drawings. All works shall be carried out in conformity with the drawings approved by the board. The available drawings ready at present may be seen by the tenderers at the office of the board. The contractor shall have to carry out the works according to the detailed drawings which will be prepared and furnished during the execution of the work from time to time. These are drawings that are prepared by my engineer in charge, available with the tenderer. They have to carry out works as per these drawings and these drawings alone. Any further, they have to obtain the consent of the engineer in charge. In essence, that's my case. Number one, contrary to the terms of the contract, inasmuch as no consent of the engineer in charge obtained. Number two, it's a finding ex facie without evidence. Not in ignorance of evidence, without evidence. Now, on claims 5 and 8, one additional point I've taken in my supplementary note. If has my supplementary note once. I've also taken the point of non-arbitrability in respect of these claims 5 and 8. Specific, I've taken that in my supplementary notes. Now, the first heading, we'll see. Clause 5 and 8 state, claim numbers 5 and 8 relate to additional works. Disputes and differences in respect of such additional works are non-arbitrable inasmuch as amounts payable in respect of such works are to be determined by the joint director, and such decisions shall be final and binding. I'm relying upon page 51 and 52, clause 12. So the joint director, while sanctioning the final bill, has not taken into account these two claims. Therefore, that decision is final and binding, and that has been that's a clause signed and accepted by the contractor as well. That apart, we'll see. I've referred to the letter also where the joint director's decision is there. Page 624, I've referred to that in my note. 624 is the letter of the joint director which denies these claims. Now that's there, the last sentence. So, it's an admitted position. Claims 5 and 8 were not permitted by the joint director. Therefore, no claim can be raised on that ground before the arbitrator. They're non-arbitrable. Thereafter, claim 9. Claim 9 relates to additional excavation and earthwork done by the respondent. Here, again, the point as to wrongful placement of piles comes in. Will kindly take my note, page 12. The first note, page 12, will kindly have. This claim relates to alleged additional earthwork, excavation work done by the respondent over the contractual quantity, over and above the contractual quantity. Now, the findings, may I just quickly place? It's a very short finding as to this head. I'll just place it very quickly. Claimant states that they executed 9805.465 cubic meters of earthwork, but had been paid for 6624.418 cubic meters. Amount claimed is rupees so and so. Location of pile caps being close, it was not possible to execute strictly according to drawing without executing shoring work all round. Therefore, the arbitrator takes into consideration that the drawings which are a part of the contract and accepted by the contractor, they require additional work to be done in terms of excavation. Thereafter, my lord, we'll see what the arbitrator holds. Considering the reuse of planks, continuous work of pile cap was not feasible. Apart from the delay, the respondent would have to incur very heavy expenditure for shoring work. Claimant informed about their intention of open excavation. Respondent never disagreed. Never disagreed. There is no positive consent from the engineer in charge as is required by the terms of the contract. Never disagreed to the claimant's proposal or objected to open excavation. The claimant eligible for extra excavation of so and so. The aforesaid finding, my lord, this is my submission now. It is just a one paragraph finding, my lord, in an item rate contract where all rates are inclusive of everything. It is ex facie, my lord, contrary to the terms of contract. My lord, here the work done as to boring of piles, my lord, this was accepted by the contractor as per the drawings that were part of the contract. My lord, now difficulties that might arise subsequently during execution of that contract cannot entitle them to any additional payment. My lord, will kindly, and one other point, my lord, here I had taken a specific defense that's available at para 30 and 30 at page 377. And my lord, this was not disputed. I had taken a defense which was not disputed in the reply. That's the totality of my submissions, my lord. Item rate contract, therefore all rates are inclusive. And the arbitrator had failed to consider my defense. That's at page 377. My lord, may I just place 377, my lord, just for my lord's satisfaction. Page 377, that's volume 3, I believe. My lord. Volume 3. Yes, yes. 377, my lord, is a part of the statement of defense. My lord, claim 9 is dealt with in para 30, 377. Para 30. But may I very quickly place the unnumbered paragraph right beneath para 30, where necessary as per drawing for erecting brickwork as shuttering, pile cap, excavation of foundation is required, providing for allowance of so and so. In fact, excavation for group of 25 to 30 caps, pile caps were not at all necessary. The question of payment of earthworks is not maintainable. Therefore, my client's contention, apart from the fact that this is an item rate consolidated contract, is also that this work was not necessary. The arbitrator does not consider this defense at all. And passes an award only on the basis of the averments of the claimant. And this is not, my lord, will kindly just have a note. Page 653, para 30 is their rejoinder to this, is the claimant's rejoinder to this, where they do not dispute it. My lord can have a note. I will not trouble my lord with that again. Page 653. That's on claim 9. A couple of claims in my supplementary note. My lord, I believe there's a fixed matter at 3 o'clock. I'll take, my lord, 10 minutes. I won't take much time. And my lord, the judgments I'll just indicate. BCCI Kochi Cricket to say that pre-2015 Amendment Arbitration Act will apply. And there are, after a couple of judgments, my lord, only on where there's a contractual bar, no claim is permissible. Only on that. My lord, 15 minutes on each, any day, my lord.
देखो Mukhopadhyay.
Yes.
Mr. Mukhopadhyay, learned counsel representing the appellant, resumes his argument but does not conclude. Paragraph. This is the matter Friday.
Tomorrow, my lord. Tomorrow I'll
Tomorrow
come back,
let it be there. Yes.
Yes.
Be there. List the matter once again. Calcutta retaining its position.
Obliged. My lord, one. Okay.
Fixed matter item number 18.
Which matter is this?
My lord,
This is the matter where, my lord, we are for IDFC Bank, pro inter suo, my lord, where the point was, my lord, whether the appeal is maintainable and whether Dhanbad Fuels will apply, my lord, the 12A leave. I'm sorry, my lord. It's a 3. I'm sorry, my lord. That's ACD 1 fixed at 3 p.m. So I'm sorry.
What has been called?
It's
Because
a combined matter, my lord. Item 1 and 18.
1 and 18 are being taken up together.
One is this matter which I just said, Lord. This is
the matter in which your lordships had appointed Mr. Bhattacharya as the amicus to decide the question, my lord, with regard to appealability from a deemed decree of the commercial court.
I appear for the respondent number 1, my lord.
The original side matter, my lord, Mr. Bhattacharya was on his verge of his completion, the amicus.
Yes.
I saw.
And my lord, I had indicated that I have submitted a notes, my lord. Which of the
one and 18. One of what?
Mr. Shatarup Banerjee, who is opposing me, my lord, should take up cudgels first, so to speak.
He's not around.
Yes, I am there, my lord. I am appearing virtually, my lord, since I'm not in Calcutta, my lord.
Virtually, sorry, Mr. Banerjee, we don't like to hear anybody virtually.
Then my lord will.
My part.
Yes, you conclude.
He would be awake.
You conclude.
Yes, my lord. Let him conclude then, my lord.
তুমি তো একাই 100 তুমি করে দেবে।
But I had indicated to your lordship, my lord, that what we appeal against is an appeal from a judgment, not a decree. And my lord, I had indicated the amendments to the CPC which were brought about. Because judgment is the reasoning behind any order or decree. So 13.1, my lord, what I had indicated in my 13.1 is an enabling provision which allows appeals to be preferred, subject to the restrictions under Order 43 when it comes to an order. 13.2 is a disabling provision, and the kind of decrees which are non-appellable, I had indicated to your lordship, decrees like, my lord, under Order 7, Rule 11, B, E, and F.
1 second, Mr. Bhattacharya. Mr. Roy Chaudhary. Yes. We'll dispose of this still, but include direct inclusion of a copy in the informal paper. Stay application stands disposed of. So, however, the copy of the stay application be included in the informal paper book for convenience of reference. Dispose of state. Yes, Mr. Bhattacharya.
My lord, will.
Thank you.
Which will.
How long will you take, Mr. Bhattacharya? 5 minutes.
I had concluded. I had almost concluded, my lord, if your lordship recalls.
After that, will you argue? No. Then, Mr. Banerjee,
I can indicate, my lord, basically what I am trying to say.
Let him conclude.
Yes, in a short.
Because then we are not releasing the other matters. It does not appear that this matter will continue for long today. Yes.
will kindly, this will not apply to, because it does not record reasons while dismissing a plaint under Order 7, Rule 11C, E or F. And I had shown, my lord, Order 20 also, that what we actually appeal against is from judgment. Order 20, Rule 6B. First, Order 20, Rule 6, my lord, that I have indicated in my notes of argument, in the notes which I have supplied, my lord. The decree shall agree with the judgment. It shall contain the number of suit, particulars of the claim, and shall specify clearly the relief granted and other determination. The decree shall state such and such. Now, my lord, 6B, this was introduced in 2002. Where the judgment is pronounced, copies of the judgment shall be made available to the parties immediately after pronouncement for preferring an appeal on payment of charges. So, we
Yes.
Now, similar, my lord, amendments were made to Order 41, Rule 30. Rule 30. And 31. But what basically Section 13 tries to do is, my lord, the vast my lord, interpretation given to judgment under Clause 15 of the latest patent, that has been restricted, in my humble submission. But even if it is a deemed decree under Order 7, Rule 11, for example, my lord, your lordship takes a plaint and decides to reject the plaint on the point of limitation. That puts, it becomes a res judicata. It becomes a res judicata. But for that, I'm also carrying a Madras High Court. It's some vintage, my lord, 1920 Madras, page 273. If it becomes res judicata, where will the party go? My lord, kindly takes paragraph 4.
Deciding the rights between the parties within the meaning of 2.2 of the section 2.2 of the.
It is deciding the rights of the parties under 2.2, my lord. My lord, the last page of that judgment, which is because paragraph 4 is a longish judgment, my lord. Last page, even when substantial question affecting the rights of the parties in clause A and D may not only after the plaint is registered as a suit, but even after issues are settled and the parties are heard on such issue, I do not think it can be argued that the decision on this point so heard and determined is not res judicata under Section 11. So for all times to come, so, my lord, this point of 12A also, my lord, it can be decided as an issue in the suit. One can take this point as a point in the written statement, decide it as an issue, and your lordship has to pronounce a judgment on that. That couldn't have been the intention of the legislature. And it's a valuable right. My lord, if your lordship looks at 12A, 12A now Supreme Court has said it is mandatory if there is a chance of mediation. But at the same time, 12A grants the litigant the right to approach the court if he is in need of urgent relief. Now, if the court decides that he does not need an urgent relief, for example, it always happens in IPR matters. If now the court decides no and rejects the plaint, the purpose of the suit will become infructuous. So, these are my grateful.
Mr. Saha, you'll be supporting appealability naturally.
Yes.
It's your appeal. And your trump card is Srishti.
Yes, madam.
No, yes, Mr. Banerjee, I don't see how we get out of Srishti. Mr. Banerjee has to
He has
tell us.
also,
Hmm.
we had appealed from that, and Supreme Court dismissed the appeal,
That is
upholding
mere dismissal of the
yes,
SLP.
that may be hit by Kunaya Ahmed.
So let Mr. Banerjee, when are you back?
My lord, I am back tomorrow evening, my lord. Thursday, lordship, day after tomorrow at 3 p.m. lordship keeps it. I am ready with everything, my lord. I've considered Mr. Bhattacharya's citations as well as the compilation, my lord. He has given me a copy.
No.
The interim order is till 20th. So
that's the exact day, my lord. I want to argue it out before, my lord.
Yes, has to be extended for a limited period, Mr. Banerjee.
Lordship does that on 20th, my lord. I won't take half an hour, my lord. Not more than half an hour.
All right. If that makes you happy, we'll do
kindly extend it for some time, my lord. If it is
Day
concluded.
after tomorrow, we'll do it. It's still day after tomorrow.
Exactly, my lord.
My lord, may it be on, I don't know, 20th, my lord. I am in some difficulty, 20th and 21st.
Then tell us.
My lord,
Your Lordship is aware in Patel Automation, Supreme Court has held that revocation of 12A amounts to rejection of claim. Which under Order 7, Rule 11D. If that be so, it's an appealable.
my lord, it's very interesting. My lord, if your lordship will just, I know Mr. Dasgupta will address your lordship, but my lord, just kindly have section 13 once, my lord, at my request of the Commercial Courts Act.
Well, is Mr. Dasgupta going to address today?
That's on the original side matter.
Well, I would request him to do it together only. I think that would be easier for my lords also to consider.
I'll leave it to a lordship.
It would be the same submissions, my lord. Because the points are similar. We're going to argue the same thing. So, my lord.
Yes, Mr. Banerjee, but then he is appearing also in the original side matter. There he will only have to argue.
My lord, to be very frank, we have sat together only, my lord. I don't think he will make... Exactly. So, my lord, I don't want to waste my lord's time twice, my lord.
দেখো Yes, Mr. Shah, when are you back?
My lord, except for 20, my lord, I was wondering if I could, my lord, seek to engage your lordships, my lord, on 23rd, 24th, any day, my lord. I'm sorry.
23rd,
I'm sorry, my lord. My lord, 22nd, not possible, my lord. Your lordship doesn't take it up on 20th.
No, it's not a question of day. 22nd, my lord will not be available after 12:30.
21st, my lord.
Thursday. আমাদের দুটো ফিক্স আছে সকালে একটা দুপুরে মানে
Yes, my lord, at 3 p.m. lordship keeps it on 21st. I have no issues.
21st can have 12:30.
Of course.
আমাদের 12টার সময় একটা আছে কোথায় ওটা 5-10 মিনিট
21st. Mr. Banerjee, 21st, Thursday.
Yes, 12:30 is all right, my lord. I'll be there before, my lord.
অর্ডার করো, কিভাবে অর্ডারটা করবে আমি জানি না। আলাদা আলাদা করে করো।
Lordship, I apologize for interjecting at this point just before Lordship pronounces.
21st option.
Dictates the order. May I just draw from Mr. Bhattacharya's point on the Order 7 Rule 11 plan and just place a latter judgment of the Honorable High Court at Madras, somewhat on the same point with respect to the fact that Order 7 Rule 11, it's an final adjudication of my rights and hence it is appealable under Section 96.
Come back on Thursday. You have a right of audience, Mr. Chakraborty. You are appearing for the appellant. You are not being led by anybody. So we'll have to hear you. We would like to hear you.
21st, I have some difficulty, Millet.
Then you decide, all of you. It's impossible for us then. হবে হবে পুরোটা ফাঁকা আছে 26 কি বার
26
Well, your lordship,
26th
very well.
3:30
Yes.
আমরা ভার্চুয়ালি করছি কিন্তু আমরা
you are excused
26 এখানে তাহলে ভার্চুয়ালি করছি
you'll be spending time
Keep it, my lord, on 20th as your lordship suggested. My lord, in case, my lord, I am in some difficulty, let Mr. Banerjee finish, my lord,
Yes,
first.
yes. I was only saying this, my lord. Let me complete it on 20th.
He'll take some time, my lord.
20th কি ফাঁকা আছে
No, your lordship said, my lord, 20th. That was the date your lordship indicated.
At 3 o'clock, my lord.
20th will be at 12:30 তাই না
No, 21st lordship said at 12:30.
নাকি 21st ও ফাঁকা আছে
কি করবো রোজই বাইরে
ওনার মিস্টার দাশগুপ্ত is in difficulty
That's exactly I'm saying 20th, my lord. I am coming. I can come on 20th even, my lord.
Mr. Rudraman Bhattacharya, learned senior advocate and amicus curiae, concludes his submission.
Have been assisted, be
Acha.
assisted by Mr. Tiwari and Mr. Banerjee.
Learned senior advocate and amicus curiae, ably assisted by Mr. Harsh Tiwari and Mr. Siddharth Banerjee, learned advocates, concludes his submission. Stop. We record our appreciation for the assistance extended to us by all the learned counsel. Stop. Paragraph, list this matter once again on Porshu dinin tarikh dao. Marked koto bollam? 12:30 p.m. When learned amicus curiae need not be present as he will be spending time in better company.
My lord, may I request that the interim order, my lord, be
Yes.
extended by a week?
Paragraph in the appellate side matter. In the appellate side matter.
Appellate side number 1.
The appellate side interim order that is in operation shall stand. We have kept it on the 20th, though.
Yes.
Shall stand extended till August 25 or until further order, whichever is earlier.
Grateful.
Very well. Great.
Grateful. এইটা amicus curiae যা দিয়েছেন তার সঙ্গে রাখো কিছু নেই আমার কাছে
Second call, item number 12.
With no intention of rushing you, but only for the benefit of your learned friends, will you keep us engaged till the end
My
of
lord,
the
I
day?
My lord, lordship would recall on the last day I had made my submissions. This is with regard to the section 9 application, where my lord, their application has been rejected. The application arises from an agreement of March 2013, and my lord, the learned judge has been pleased to hold that there are serious issues whether there was another agreement of October 2013. So, my lord, apropos that, my lord, I had taken your lordships through the March 2013 agreement. My lord, kindly take the list of dates once. That while I had the last day's concluding point which I had shown to your lordship, that the agreement itself had a date of performance stipulated, which is that you had to buy all the shares
31st July.
by 31st July. And my lord, I had asked a question to myself that if the petitioners or petitioners in the section 9 would have come up, that is the appellant before your lordship would have come up to a section 9 court in August or in September of 2013, would they be entitled to any order of injunction?
If not, then it at
If
least
not, then can they be entitled to any order of injunction in 2023? I am not on that, my lord, whether under section 18 limitation has been extended or not extended. I am on a basic prima facie case that, my lord, if we come up on the very next months, my lord, either under order 39 or section 9, my lord, lordships frequently ask, there is a cut-off date, you have missed the date, no interim order. So, my lord, my first point, which I made on the last occasion, was that without going into the issue of limitation, I am conscious. I show also that it is on the face of it, but no need for giving any effort. But if on 31st July a cut-off date is there, with the condition that my client is free to sell the shares, my lord, lordship will find that 17th March, my lord, at page 29 it starts of the paper book. I just recap that and move on, madam. Page 29 of the paper book is the 17th March agreement, and my lord, the clause 28.5 crores, my lord, the total consideration is mentioned at clause 1.2. And then, my lord, 1.3, lordship will find the schedule of payment and transfers. Sorry. Paper book, page 23. বারবার ওই ক্লজটা হারিয়ে যায় আমার।
সাহেবকে তো আমার লাগবে না।
হ্যাঁ, ঠিক আছে। আগের দিনও তুই বলে দিয়েছিস।
তো মনে হচ্ছে মামলাটা পড়ে গেল। Right. Subject work was boring. Very boring and extra boring.
Lordships have got that one? Lord, 1.3 is at page 33. Lordship will find at 1.3, 31st July has been mentioned. And then kindly straight away come to, Lord, I had already shown to your Lordship clause 3. Now, this is where I ended on the last occasion. I was at clause 5, and in clause 5.1, parties of group 1 jointly and severally expressly undertake, they shall not dispose of, transfer or encumber the shares in any way, except as has been contemplated under this MOU. However, members of group 1 will be free to deal as per their wish with their respective shareholding if consideration as defined in clause 2 is not cleared by 31st July. And consideration as defined in clause 2, let kindly see clause 2.
Clause 2 of what?
Clause 2 of the same agreement at page 34. 28 crores is the total consideration.
Yes.
And Millard, the shareholding is, Millard, this is the entire 55 lakh share. So, Millard, in section 9, I have my first point in answer is that even if they would have come with this case which they are making out in 2023, in the very next month of August or September or any time thereafter, they would not have been entitled to any interim order for the simple reason an interim order cannot be in violation of a clause of an agreement. Forget what final relief they would get. They cannot ask a final relief because, my lord, the agreement itself permits me to sell it off. And it is not, my lord, dependent upon whether they release any personal guarantee or they do not release any personal guarantee. So, even if, my lord, and I am not going into the issue of whether the October agreement supersedes the March agreement. I am making this argument, my lord, taking the agreement on the face of it as it is, that they are not entitled to any interim order because it will be in violation of clause 5.1. After 31st July, I am free to sell to anybody. So any order of injunction will be in direct violation of clause 5.1. Now, my lord, I come to my next point. Lord, an argument has been advanced that yes, it's correct that we did not do anything in 2013, but then in 2017, we got all the bank guarantee released, and a paragraph was shown from this that these bank guarantees were released pursuant to the March agreement and not pursuant to October agreement. This was one of the important submissions which Mr. Mitro had made. Now, my lord, kindly compare 2 pages, my lord. Let kindly first take page 113 of the paper book.
The
page 113. And my lord, kindly side by side keep open, my lord, page 269, which should be in the other volume. Volume 2. Volume 2, page 269 and 113, my lord, which is part of their section 9 application.
মোটা বইটা সরাতে হবে।
তো পাশাপাশি করা যায়, টেক্সটে ইয়ে নস, তুই না তুই পারিস না করতে বলছিস না, ছেড়ে দে, ঠিক আছে, দরকার নেই, এখন ঝামেলা করিস না, এরকমই রাখ, কাম করে দিচ্ছি। এটা সেকশন নাই। But 113, Lordship will find, is part of the section 9 and the heading is clear. Statement showing discharge of personal guarantees in the petitioner pursuant to MOU dated 17th March 2013. And this is the self-same Mr. Lakhotia, my lord, coming in 2023 and affirming this. And submission is made, well, these were released pursuant to March agreement and my lord, all these approbate, reprobate judgments were shown. I was surprised why he is showing it, because I have not altered my stand. He has altered his stand, my lord, 3 times. Now, kindly compare this with page 269. This is a part of the suit of specific performance seeking enforcement of the October agreement. And my lord, schedule C, lordship will find, I'll come to the pleading later. My lord, lordship can take it from me that the entries are identical in both the pages, save and except in page 113, the last entry is an additional one. State Bank of Mysore, that is an additional one. Other than that, the entries are identical. And my lord, in 269, kindly see the corresponding pleading.
This 269 is part of?
My lord, it is part of the suit. An application, interlocutory application filed in the suit for specific performance, seeking specific performance of the October 13 agreement. And my lord, the corresponding pleading in support of page 269, Annexure C, is paragraph 7 and 8, which is at pages 253 and 254. And these pleadings are all in the context of October 2013 agreement, affirmed by the same gentleman. It was further agreed between the parties that personal guarantees given by Ram Gopal Maheshwari and Maruti Maheshwari on behalf of MBL, particulars whereof are given in a schedule annexed hereto and marked with the letter A, would be discharged by the petitioner and would transfer its 17 lakh equity share in MBL in favor of the petitioner at 63 rupees 75 paisa. This is well at 63 rupees 75 paisa because this is the figure in the second agreement. Original agreement was 53 rupees. 53 rupees. Out of the 17 lakh equity shares, 5 lakh equity shares were lying pledged. This is the same pledged shares, my lord, which the bank has, my lord, adjusted in respect whereof they have filed a GA in this and all that. All these are being, my lord, pleaded in the suit as subject matter of that agreement. They have taken exactly the opposite stand. Accordingly, an agreement was entered into between the parties on 30th October 2013. So, my lord, the entire submission which, my lord, Mr. Mitro tries to make to suggest that I have taken a contrary stand, my lord, is incorrect. On the face of the record, I am showing your lordship that the subject matter of the 2013 agreement of March and the subject matter of 2013 agreement of October, my lord, the subject matter is identical in the sense that it is the same set of shares, only the numbers have reduced. What had happened, my lord, after 31st July passed away, and I'll show that, I start selling in the open market. They start buying in the open market, from the open market. And I have also made a chart, I'll come to that shortly. My lord, if a promoter or, my lord, a promoter of a company buys a share in the open market or by private treaty, my lord, the law casts an obligation on both the buyer and the seller to disclose it to the public, so that, my lord, insider trading and all these things are not done. I show the statute also. And, my lord, they only show some of the entries, but, and, my lord, they don't show all the entries are corresponding, matching in the disclosures. I have made a chart and I show the falsity of their contention, but I am now dealing with their argument that, look, there was a cutoff date of 2013, but then I got these only on the assurance of the March 2013 agreement. I got the personal guarantees released in 2022 or 2023. And they themselves had asked for that in 2017. I'll show, my lordship has seen 2017 when I asked for release, he says there is no agreement between the parties because the March agreement had expired. But his case in the suit in GA is that these personal guarantees were released because of the October 2013 agreement. That's his case. And, my lord, I adopt the same line, my lord, all those decisions of approbate and reprobate, lordship has seen. that you can't blow hot and cold at the same time. You have taken a stand. So, my lord, October 2013 agreement was a new agreement. Why? Because, my lord, 55 lakhs were the original quantity of shares. In between, my lord, July, the cutoff date, August, September, my lord, 2 months I had sold off some. But, my lord, the shares of Prabhu, the 17 lakh odd shares, that remained. Therefore, in October, what happened? The two corporate entities entered into an agreement. And by that time, the share prices had risen also. So, all right, I could not, whatever you have done, we have done. These shares I will buy from you. When I say I means the corporate entity MBLA, again signed by Anjani Lakhotia. I will buy from you at 63 rupees, which is a higher price. Now, my lord, I ask a question to myself. The case is, and that was also the case made out before the learned single judge, that these are subject matters are separate. But if 17 lakh shares out of 55 lakh shares becomes the subject matter of another agreement, and according to them, my lord, the corporate entities are also parties in the first one. My lord, we had taken a technical point that the companies had not signed separately while resisting the suit, my lord, interlocutory application in a suit. And my lord, factually, that aspect is correct. There is no separate signature on behalf of the companies. But my lord, good, bad, indifferent, the finding is an order of injunction was passed. Now, once the October agreement comes and you take this stand, can you not turn around and say that no, that is separate and this is separate because you have withdrawn that suit? And my lord, what happens if 17 lakh shares is no longer at 53 rupees but becomes 65 rupees? Does that agreement survive? The earlier agreement survive? And the same set of signatories. Here in a corporate capacity, over there in an individual capacity. And all these have been noted by the learned judge, my lord, in dismissing their application, that there are serious issues as to whether this comes. That is why, my lord, because the main attack was, my lord, on this finding. That is why, my lord, in the first submission, I said that even if you don't go into, this court doesn't go into the issue of whether this agreement overlaps the other, subsumes the other or not. I first started by showing if that agreement is assumed to still exist, then they wouldn't have got an order in August 2013, forget 2023. And now I am answering, my lord, the next contention which they have, my lord, they challenge the finding of the learned judge that this finding is incorrect, that this has subsumed that. So, my lord, I am trying to show that they themselves in the suit say that everything has happened pursuant to the second agreement. That's why I compared the two. Now, my lord, the third important
The
aspect.
suit for specific performance was in respect of 17 lakh shares held by Prabhu in MBL.
In MBL. And my lord, that was also the subject matter of the March agreement. Lordship will find at page 32, my lord, 23, the agreement starts. Kindly see, my lord, Prabhu International. Originally, my lord, 31 lakh shares were there of Prabhu. And then, my lord, the October agreement, if lordship comes, my lord, because by that time, my lord, some shares had been sold off by Prabhu also.
Yes.
So 17 lakhs were only the subject matter because they said we will be able to buy 17 lakhs at a higher price. In October only, they are offering a higher price. And then, my lord, all these stories are coming out of 28 crores. I have paid 24 crores. There is a limit to. And my lord, the groups are, my learned junior, my lord, wants me to show you recital G once at page 31. Parties under group 1 are collectively holding 55 lakh equity shares of 10 each, representing 31.77 of the current paid up capital of MBL. And I was the one who was going out. 31. And similarly, clause F will also find closely company. And in the table, lordship will find page 32, entire 55 lakh shares, individuals and the corporate, they are mentioned. And Prabhu is mentioned as a party to the agreement, my lord, in black and white, in print, but there is no separate signature from Prabhu. That was a technical objection which we had taken in the suit later. That in the March agreement, I stand by that. But then the question is now, so my lord, first lordship will note 17 lakh is out of this 55 lakh for which already there is an agreement for 63 rupees and all. That's October 1. And then, my lord, most importantly, I have shown that their stand in the suit in an interlocutory application was that the personal guarantees were released pursuant to the October agreement. That is their stand. And then, my lord, the next point is, in between 2013 to 2023, for 10 years, lordships will not find a single correspondence referring to the March 2013 agreement, either by them or by us.
This is between, you said, the time period?
Well, 2013, March 2013 is the agreement. They filed the section 9 in 2023. So in between 13 to 2023, they filed the section 9 in 2022. In between 2013 to 2022, not a single correspondence referring to this agreement at all. It was 17 HED. Now, this is the only letter which Mr. Mitra relied, and also his reply when my lords only remarked that you have yourself denied it. Well, they assumed I was invoking the March letter. That is also the case in the section 11 also. Well, kindly come to page 282. না আমার চিঠিটা আগে দেখো তারপর এটা দেখো I'm sorry, my lord, before 282, kindly come to my lord 116. Page কত এটা ডেটটা কত ডেটের এটা লিস্ট অফ ডেটে দিসনি না এমনি দিয়ে লাভ 116
September 15 September.
Yes, my lord. This was construed not only before your lordships but also in the section 11 court that I myself am invoking the March agreement. This is their contention. Now lordship will not find that this is referring to any agreement at all. It is simpliciter saying the subject matter lordship will find notice under section 13(2) of the Securitization and Reconstruction Act. And then my clients are writing this as reference to the above correspondence that we have received from and on behalf of Bank of Baroda. Because, my lord, we had resigned in 2013. Bank of Baroda Corporate Financial Branch, and our replies thereto. We had also marked a copy of the aforesaid notices to your good self with a letter of 28 July 2017, but did not get any feedback nor any reply for action taken by you against the aforesaid notices. You are well aware I had resigned from the board of UP Infrastructure in August 2012 as a part of settlement of dispute between us. You were supposed to get my personal guarantees released from the bankers of AAP Infrastructure. I had resigned from the board of AAP on 18th August 2012, copy enclosed, and have never thereafter granted and guaranteed the alleged loan to Bank of Baroda. Under the circumstances, you are requested to urgently sort out the matter with the bank at the earliest and keep me indemnified. You are also requested to share the correspondence made with Bank of Baroda after my resignation from AAP Infrastructure for securing the release of any personal guarantee. The reply to this letter is at page 282. 282 and 283. And the same gentleman is writing. Lordships may have marked this because Mr. Mitra also showed this, but he said that nothing transpires. What stand I take? In law, whether agreement survives or not, that is to be seen. That was his contention. I am surprised to receive your letter dated 15th September. At the outset, I deny and dispute the contention of your letter. It is denied that there exists any settlement of dispute or agreement by which I am responsible for getting your personal guarantee. He in fact denies both the agreements. Please refrain from making such baseless allegation. My lord, similar is the line, my lord, written to another of the petitioners, same language. One is to here. And my lord, the two letters are identical in content. One is written as A.K. Lakhotia and one has been written in his capacity as a director of MBLA Capital. Lordship will find, my lord, the contents are same. One is written in his personal capacity and one in his capacity of MBLA. Now, my lord, Lordship will notice why this requirement to write in two capacities. If you are only relying on the March agreement, no need to. But irrespective of whether you are relying on March or October, he denies all agreement. There is no agreement. And I have already shown in the plaint, my lord, in the interlocutory application in the suit, my lord, the chart have been pleaded all in pursuance of the October agreement. And in the suit, they enjoy 8 years of injunction. And when I say that my lord, there are letters, I'll come to that. I write letters when the price starts falling. I said, it's falling, you buy it at the agreed price of 53 also. Sorry, 63. October was 63. Well, they don't respond, then we take out a judgment upon admission. When it is to be heard, my lord, they come and withdraw the suit. Lordship has seen the orders. And my lord, in the suit, a restitution has been filed. Because, my lord, we had opposed that, but my lord, the learned judge recorded that if they want to file it, withdraw it. But restitution, Lordship knows, that's a separate issue. And my lord, no leave was granted in that suit. So now, what they do is, when they have taken the decision to withdraw, my lord, they try to invoke this agreement.
This should withdraw the same day, section 21.
Section 21. Now, kindly have a look at the section 21 notice date, my lord. That is very important. 28th March 2023. My lord, kindly come to page 149. 149. Volume 2, 149. Kindly keep side by side page 386 also. If it is it in the same volume? No. 386 is volume number 3. But I'll in fact first show page 386 and then come to page 149. Both are documents of 28th March Page 386 is the order of Justice Rao. Counsel for the respect, I'm sorry, page 386, Lordships have that. Counsel for the plaintiff has handed over a communication dated 25th March 2023 and 25th March 2023, wherein the director of the plaintiff had informed the advocate and record of the plaintiff that the plaintiff does not want to proceed with the matter and requested the advocate on record to withdraw the suit being CS 54. In terms of the communication dated 25th March, counsel for plaintiff prays for withdrawal of the suit without any leave. Counsel for the defendant raised objection and submits that the plaintiff has obtained interim order due to which the defendant is not in a position to sell the shares, due to which the defendant has suffered loss, and as such simpliciter this court cannot pass an order for withdrawal of the parties to the suit. Consider the prayer made by the respective parties. This court finds as the plaintiff is not interested to proceed with the matter, and as such this court has no other option but to allow the prayer made by the counsel for the plaintiff. Accordingly, suit so and so is withdrawn. And now, Lordship will find Millard at page 386. This order is passed in the suit, but at the top, Lordship will find GA3 of 2023. GA3, Lordship will make a note, is my application for judgment upon admission, which appeared for the first time on that date. Judgment upon admission of prayer. And Millard, now kindly see, Lordship has seen 386, now kindly come to 149. Page 149. So 25th, Anjani Lakhotia instructs the advocate. 28th, the submission is made. On that date, when the suit is withdrawn, on the same date, a section 21 is issued.
Judgment upon admission, the plaintiff, it was submitting to the decree. Submitting to
Oh, whatever, but I am admitting the charge against me that there is an agreement.
So you wanted a decree to be passed.
I wanted a decree.
Yes.
I am willing to sell it. It was a suit for specific performance. It was an admission of performing the contract which has been pleaded.
GA3 is there, page 333.
But GA3 prayer, Lordship will find at page 333 in that volume itself. The notice of motion has been annexed, my lord. The prayer portion, sorry, the prayer, yes.
No, prayer is not there. 333, no. 333.
Notice of motion is there, 333, 334, I'm sorry, 334 bottom. 12 lakh equity shares of MBL infrastructure and 12 lakh bonus equity share of MBL held by the petitioner to the respondent plaintiff upon paying a sum of 15 crore 30 lakhs being the aggregate value of the said 24 lakh equity shares in terms of the MOU dated 30th October 2013.
This was a googly.
This application was necessitated because during the period from 2017, 2015 onwards, we have written repeated letters in the suit that you take it at this price, you take it at this price. And moment when this application was made, they withdrew the suit. And on the same day as section 21, this is on bona fides, my lord, bona fides. And section 21, my lord, 149, Lordship will see. It's 28th March 2023, the same date of that of Justice Krishna Rao's order.
Yes, this Krishna Rao was 26th March, wasn't it?
28th March, same day, same day. After the suit is withdrawn, this letter is issued on that date itself.
386. 28th March.
386 page 386 is 28th March order, 149 is section 21. Now, section 21 invocation is interesting. Now, this is the reference to paragraph 1 is the reference to the agreement of 17th March. And this is coming in after a period of 10 years. After 2013, this is the first time a reference is coming in 2023. Then para 2, kindly see how they are pleading the consideration. 28 crores, which was in 2013, notwithstanding 31st July, still remains 28 crores. No appreciation over there. Their right continues, but the price is fixed. Fixed price contract. In terms of MOU, consideration may be shared, distributed proportionately or otherwise as mutually agreed, subject, however, net consideration shall not be higher or lower than 28.5 crores. Para 2. Then para 3. This man has, my lord, written statements whenever and whatever suits him. As you are aware, in terms of the MOU of 17th March, I have discharged all my obligations. I have caused release of all personal guarantees. The very same person who in 2017 denies there is any agreement. He is writing this. I have caused release of all personal guarantees of Group 1 and more particularly of Maruti Maheshwari, director and person in control of Prabhu, in short Prabhu. Payment of an aggregate sum of 24.96 crore to Group 1. This is also false. I'll show that. Because this is, my lord, the story was, my lord, spun later that if we adjust, if we give credit to all that we have bought it, then, my lord, we can adjust the gift. The figures will not match as if it is in terms of that. But I'll show the fallacy. A copy of MOU of 17th March is enclosed. After denying any agreement in 2017, he resurrects on the same day because, well, no injunction had gone. In the suit, they were enjoying injunction from 2015 till 2023. I was restrained from selling any shares. When I say I, my lord, Prabhu was restrained from selling those shares. And then, my lord, when we come up with that application, they withdraw the suit, injunction goes. So, my lord, plan B, I invoke 21 of a 10-year-old agreement, section 21 of a 10-year-old agreement, and I come up with this. But, my lord, it has to be appreciated. There is a method in the madness. My lord, we may say this, but, my lord, more I see, my lord, it's very, very, the design is, my lord, I don't say evil or good, my lord, but that is relative. But, my lord, the design is interesting, my lord, to say the least. And then, my lord, kindly see.
Complimenting your client.
And then, my lord, kindly see, my lord, section 21, para 5. Aditya Maheshwari has acted in terms of MOU dated 17th March by transferring 36,458 shares and have received consideration of 43 lakhs and odd as would appear from particulars in Annexure 2. Aditya Maheshwari resigned on 31st October 2013. Present notice therefore is not being issued to Aditya Maheshwari. But kindly note, if this would have been in terms of March 2013, and others would not have done it, very next day you would have issued in 2013 itself, not in 2023. Then Anuj Maheshwari has acted in terms of MOU by transferring so and so, received consideration as detailed in Annexure 1. Anuj Maheshwari, I'll show how, at what price Anuj had sold in open market where they had bought it. And I'll show, my lord, the two disclosures also. And there are about 5 lakh shares which are not part of either of the disclosures. So it's in open market. Well, even if promoters sell shares in open market, well, as per SEBI regulations, well, both parties will have to make disclosure. Any transfer of shares in open market, private treaty or otherwise, as per SEBI regulations, both the parties are required to. by promoters. So, my lord, if their case is from their chart, that 24 crore story, what about 5 lakh shares where you don't have any such chart? Show that. And I have made a comparison. I'll come to that. But I am now, my lord, on the section 21 notice. Kindly come to para 8. But since, my lord, they are aware that I had taken a point in the suit, my lord, they say MOU dated 17th March was signed on behalf of Prabhu by its directors and authorized signatory Ram Gopal Maheshwari since deceased. Maruti Maheshwari and Anuj Maheshwari, consequently, it is bound by the terms thereof. Well, they are also aware that in the March agreement, there is no formal signature of Prabhu as a director. Because, my lord, their lordship has seen even Lakhotia was writing 2 letters on 17 when he is denying all agreements. He is once denying in his individual capacity. He is denying also under the MBLA letterhead. 2 letters are there, same content. I deny any agreement to release personal guarantees. Then we're at para 10. I'm sorry, para 9, my lord. Parties to the MOU have given a go-by to the timelines therein by their acts and conduct by both oral and in writing. Reliance placed by Prabhu on the MOU dated 30th October is totally misplaced. The said MOU dated 30th October is not valid and not subsisting for diverse reasons. Well, this is being written on the same date when their suit is still alive or was withdrawn.
Next day,
One day, it was mentioned the day before and then it was appearing the very next day. To be mentioned. And he is saying, my lord, the same agreement, he is saying it is irrelevant or it is totally misplaced because he has withdrawn it either on that date, on that. Overnight, my lord, stand changes. The said MOU dated 30th October is not valid and are subsisting for diverse reasons. That apart, the MOU of 30th October has nothing to do with the MOU in question of 17th March, and reference to arbitration is being made of dispute arising under 17th March agreement and October 30, which anyhow does not have any arbitration clause. Well, I have not raised any issue. He is assuming I am going to raise it and he is writing. This is a section 21 invocation. And the agreement is so old, he has to enclose the agreement. And after 10 years, first time. And then when para 10, CS 54 and orders passed therein by Honorable High Court at Calcutta, High Court, has nothing to do with the MOU in question dated 17 March 2013. And all the judgments of approbate and reprobate because of the stand that I had taken in the suit while resisting interim orders, and all are valid points in law. Not on facts. I have not made misrepresentation of facts. Here, my lord, they have made misrepresentation of facts. That is why I compared the 2 charts. The release of personal guarantee chart, when it suits them, it forms part of an interlocutory application in the suit. All personal guarantees were released pursuant to October agreement. Then after, on the same day, this mischief is done. So section 9 is filed after this. On 28th March, after this, section 9. Same chart, 1 addition. And the same gentleman, my lord, is signing. Same gentleman. First, he denies the agreement. 3 stands, my lord. Simultaneously, 3 stands he have taken. Then, my lord, para 11, I need not trouble your lordship. Kindly come to paragraph 12. The personal guarantee of Maruti Maheshwari has been released. None of you can have any objection to transfer of 17,04,158 equity shares of MBL infrastructure. The other 3858 equity shares of MBL held by Prabhu and other group have already been transferred against the balance consideration amount of 3.54 crores in terms of said MOU. Well, it is not saying transferred to whom. They are saying you are now to transfer 17 lakhs shares for only 3.5 crores. Here also he is conscious. it goes without saying all the 17 lakh bonus shares issued on 1:1 basis against the 17 lakh would have to be transferred to me in terms of clause 5.2 of the said MOU. Clause 5.1 of the March agreement says 31st July. After that, I am free to sell. It doesn't refer to 5.1, it refers to 5.2. And this is on the same day he withdraws that suit. And the demand is being made against Prabhu. He is wanting the Prabhu shares because my lord, individual shares, my lord, have all gone in the meantime. And Prabhu shares were the subject matter of the suit. So the self-same subject matter, he is now making it a subject matter of the earlier agreement, and he is trying to revive the same claim in respect of the same suit which he has withdrawn. Identical. Yes. Now, my lord, lordship will kindly take. So, my lord, this is where it stands. And my lord, my learned friend has already made the submissions on approbate and reprobate. Kindly take all the cases cited by me. Approbate and reprobate is a principle of doctrine of election, which is applicable not as to the stand taken in a suit. With respect, I am saying this. I can take different stand in law in a suit, but I cannot take contradictory stand on facts. Here, my lord, approbate and reprobate is a doctrine of election on the same document. You cannot take two stands. And my stands were what? That the insufficiency in stamp, therefore invalid. In law, I can take that. And, my lord, it is also a fact that the March agreement did not have separate signatures from the corporates. In law, and it is factually, my lord, I showed from their pleading. But I haven't taken contradictory stands vis-a-vis the agreement. I haven't denied agreement. None exists. 2017, no agreement. Then withdraw the suit and then resurrect that agreement. So, my lord, the decision cited by them on approbate and reprobate, kindly apply it on these factual cases. The two letters of 2017, the withdrawal of the suit, and the section 21 notice, my lord, there cannot be a better example of a turncoat than this. Now, well, at the next point which was shown, page 108 was relied by my learned friend. And all this I am showing from their application and their chart. Page 108, well, they show a total sale of around 24 crore shares. 24 crores. 24 crores. Value 24 crores. And in that, well, the per share value has also been given, price per share. And lordship will see the dates. It is from 16 September. Oh, I'm sorry. Page 108, lordship. Now, let us take the story which has been spun by them, that let us assume for the time being to be correct. That we are selling at the market, and the rates, lordship will find 31st July was the cutoff date, as if I have disregarded the March agreement and I am selling it to them. But kindly see their chart. 16 September, shares are sold at 70 rupees, not 55 rupees. And these were market rates. Well, these can be verified. And these are their chart. I have not given this chart. This is a chart in the section 9. September, 70 rupees. October, 64 rupees. 163 rupees, around 60s, then 75. Then lordship will see 10 December, Prabhu International, 80 rupees. 5th December, 83 rupees. 12th December, 84 rupees. It goes on. And last in 2014, lordship will find 287, 289. And my lord, kindly see, they are disclosing some sale, they are writing sale, not disclosing who is the buyer. And some, my lord, lordship will find inter-transfer. So, my lord, lordship will find in the third column, right up to the sale, my lord, prior to that inter-transfer, up to 12 December 2013, these are sales in the open market. And that is why, in respect of these sales, my learned friend could not show your lordship, my lord, those SEBI firms. I have made a comparison. All the firms disclosed, I have made a chart. I'll hand over shortly. These are shares in the open market. I start selling them after 31st July in terms of clause 5.1 of the March agreement. And then, my lord, inter-promoter transfer, they also buy at that rate, at market rate. All these rates, even inter-promoter at market rate. And, my lord, because of the gift, there is a gift also. But the story that the 24 crores can be by gift, the overall average share has to be that 28 crores was arrived at in 2013. July, you give it 53 rupees with the value. I can understand. You can take gift, you can take, understand, but not thereafter. And there also the figures will not match. Now, my lord, in this, lordships have been shown, my lord, two forms. One is under SEBI prohibition of insider trading regulations, and my lord, the another is under SEBI substantial acquisition of shares. My lord, kindly take the two regulations first. Lordship will understand the scope of this. My lord, one is the insider trading and one is this. দিলাম তো ভাই, আবার সেকশন 11 ও দিয়েছি, আবার এখানেও আইনের বইও দিতে হবে এখন। আচ্ছা ঠিক আছে, জাজমেন্ট দিয়ে দিতে পারি। তোরাই তো দেখিয়েছিস, তোদের ফর্মেরই আইনটা দেখা না, কিছু ট্যাবটা অন কর, এয়ার ড্রপ করে দে।
Insider trading regulation. Respondent is bound to disclose.
হ্যাঁ, দেখে দিচ্ছি।
The appellant is bound to disclose.
Well, first kindly take the insider trading regulations 13(4). জানি। Well, kindly make a note. Insider trading, I am to disclose. The seller has to disclose. But I handed over to your lordship, my lord, two legislations. One is, my lord, so far as one is regulation of prohibition of insider trading regulation 92, and the other is substantial acquisition of shares and takeover regulation 2011. Because the two statutory forms which my learned friend referred to are pursuant to this. Now, one is under 13(4) and 4A. Kindly first see, my lord, 13(4). Any person who is a director or officer of a listed company shall disclose to the company and the stock exchange where the securities are listed in Form D the total number of shares or voting rights held and change in shareholding or voting rights if there has been a change in such holding of such person and his dependents as defined by the company from the last disclosure made under subregulation 2 or under this subregulation, and the change exceeds 5 lakh in value or 25,000 shares or 1% of the total shareholding, whichever is lower. So this is an obligation on the transferor. And Miller, this obligation I have to perform irrespective of whether it's an open market sale or it's an inter-promoter sale. If it exceeds this limit, I have to disclose it. So if I disclose any shares where it is more than this, it doesn't mean automatically that he has bought it. And I show that he has been unable to show that. Now 4A. Any person who is a promoter or part of promoter group of a listed company shall disclose to the company and stock exchange where the securities are listed in Form D the total number of shares or voting rights held and change in shareholding or voting right if there has been a change in holding of such person from the last disclosure under the listing agreement or under sub-regulation 2A or under this change exceeds rupees 5 lakh in value or 25,000 shares or 1% of shareholding or voting right, whichever is lower. So my lord, 4 was for a director and my lord, 4A is the one which is promoter, it applies to me because I was originally a part of that.
So my disclosure would show all inter-promoter.
Now my lord, kindly note that my disclosure under this my lord, prohibition of insider trading will show all the shares irrespective whether I sell it to them or I sell it to anybody else once it crosses my lord, this 5 lakh or 1%. If I am selling more than 1% as a promoter in open market to outsiders, I have to disclose it to that. And this is where, my lord, they are trying to play the mischief to suggest that, my lord, as if I have sold it to them. No. My disclosures are because of this. Whenever I sell more than 1% or, my lord, 25, this I am to disclose. Now comes the other part. Whereas they are concerned, a buyer.
Whatever they have bought.
Yes. Now, so far as inter-promoter are concerned, my lord, the statute is the regulation 10. Well, kindly see the other statute, which is SEBI substantial acquisition and shares and takeover regulation 2011. Kindly see, my lord, regulation 10(1). Achha. My lord, in fact, my lord, my learned junior rightly says that I first show your lordship regulation 3. Which board?
Of 92 or 2011?
Well, this is 2011. Now I am trying to show, my lord, what is their obligation, why those disclosures come so far as they are concerned. Kindly see first regulation 3. This is under chapter 2, substantial acquisition of shares, voting rights or control. Regulation 3(1). No acquirer shall acquire shares or voting rights in a target company which taken together with shares or voting rights, if any held by him and by person acting in concert with him in such target company, entitled them to exercise 25% or more of such voting right in such target company, unless the acquirer makes a public announcement of an open offer for acquiring shares of such target company in accordance with these regulations. So they had to make a public announcement and an open offer. But I am buying at this price, I am also offering at this price. Now, this is the general law. Now, kindly see the exemption under which they come under regulation 10.
Those sub-regulation 30.
That regulation 10 lordship will find it should be it should be, my lord, page 30 of 77. The page number is at the bottom. My lord, it's under the heading general exemptions. The following acquisition shall be exempt from obligation to make an open offer under regulation 3 and 4, subject to fulfillment of the conditions stipulated therefore. Acquisition pursuant to inter se transfer of shares amongst qualifying persons being immediate relatives. This is immediate relatives, and persons named as promoters in shareholding pattern filed by the target company in terms of the listing regulations or these for not less than 3 years prior that. So, my lord, because of this, my lord, I am just trying to show all this, my lord, these are not germane for a section 9, but I am trying to show this, my lord, to dispel, my lord, or in trying to demonstrate the falsity in the case that has been made out from day one. Kindly see how the process of the courts have been abused. I had to suffer, and the injunction order was passed, my lord. First day they did not pass, but because we tried to take an extension in the affidavit in opposition, on that day they come and say that they are selling their shares. Therefore, kindly pass an order of injunction.
Mr. Chaudhary, your clients also never challenged that injunction order.
True.
For a higher forum.
True. Because, my lord, we were under the impression once affidavit comes, my lord, it would be clear. But then, my lord, my lord, we offered to purchase after that. Sorry, offered to sell.
That was a master stroke.
Offered to
2017.
No, my lord, that is what Lordship is seeing in black and white in the application. That comes in 2023. But, my lord, there are letters from 2017. From 2017, there are letters which we have all, these are all there in the application for restitution. It is there. You buy it, shares are falling. You buy it. We are agreeable. No response. And then, my lord, we make that application.
Yes, 1st April, 14th April, 10th May 2017.
Yes. Now, my lord, now that Lordship has seen the regulations, my lord, the reason why I am showing your Lordship this. Kindly take उधर क्यों दाओ soft copy টা দিয়ে দিচ্ছি we have made a chart আরে কি আছে I have given the page numbers also which Mr. Mitro relied. Now on the left hand column, which is the third column, Lordship will find, my lord, these are disclosures made under insider trading by us. And on the right hand side are the page numbers of the disclosures made by them pursuant to substantial acquisition of shares and takeovers. So they, because of the, I have shown your Lordship regulation 3 and then, my lord, regulation 10, they had to make that disclosure because, my lord, promoters were not covered under the general exemptions. Now, my lord, kindly see, Mr. Mitro showed that whatever I have disclosed matches over there. That is what, my lord, I have also. Lordship will find matching. And this is, my lord, table A, inter-promoter sales. Inter-promoter sales has to match. Because, my lord, under the insider trading, I'll have to give. And under the acquisition takeover regulation, they will have to give. Now it is matching. আরে বসো না ভাই আমি জানি উফ page 2 Lordship will find that matching will cover only 34 lakh shares. My lord, I am only following their chart. Then comes, my lord, note B, and these are also from that chart. Lordship will not find in respect of all these shares 24th October and all any corresponding, my lord, shares because it's sold in open market. Nil from their side. And this is 4,43,655 shares, which, my lord, the entire story of 24 crores falls like a pack of cards. This is what happens, my lord, when you say something untrue left and right. 5 lakh shares, if it goes away, then it goes. Nothing is there. So, my lord, now Lordship will come back to the order of the learned judge. What wrong the learned judge, my lord, I'll try to now support the order.
Shall we take it up?
Yes. I'm sorry, my lord. There should be a watch this side also. my lord.
Why not actually? You're right.
Because my lord, we
ওইখানে একটা ঘড়ি দাও আমাদের মাথার উপর দিও না এখানে একটু দাও দেখো Mr. Chaudhary, learned senior counsel representing the respondents, resumes his argument but does not conclude. Paragraph. Shall we just run in the list or shall
yes, my lord, I'll take my chance.
Paragraph. List the matter once again. Kalke date দিয়েছে retaining its position. এগুলো নাও এগুলো নাও
কালকে তো এমনিও হবে না বলেছি অন্য দিন থাকলে না তলায় চলে যাবে আর এইটা আমি শেষ করে দিতে চাই মাথায় এত রাখলেও মুশকিল আছে এসিটা কাজ করছে না